Royal Commission is now in session. Please be seated.
I'll just take appearances for the day.
May it please, Commissioner, I appear with Ms Berry for today's evidence.
Thank you, Ms Hogan-Doran.
May it please, Commissioner, I appear today with Mr Vial for the Commonwealth.
Right, thank you. And look, I'll just put it on the record, Ms Hogan-Doran, that you and I exchanged pleasantries at the Bar Association dinner for the new silks last night.
We did, in the company of others.
Yes.
Thank you, Commissioner.
Thank you. Yes, Mr Scott.
Before the evidence commences with the first witness, Commissioner, I seek to tender the exhibits for today's evidence as per the list which I understand has been provided to you by your associate, Commissioner.
Yes, so all of the exhibits going in now?
Yes, if it pleases.
2689 to 2807?
That's so.
Right, they're admitted as exhibits with the numbers they bear in the list. Thank you. Now we've got Ms Harfield.
Yes, I call her.
Yes. Ms Harfield, would you rather take an oath or an affirmation?
I'd like to affirm.
Okay, thanks. Could you just stand and we'll do that.
Your response is, I do. You solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth.
I do.
Yes, Mr Scott.
Thank you, Commissioner. Ms Harfield, could you please tell the Commission your full name?
Karen Mary Harfield.
And you received a notice to yourself from the Commission dated the 20th of October 2022 requiring that you provide a statement and produce documents. Do you recall that?
I was actually overseas on that date, but once I returned from overseas, I did get the notice, yes.
Thank you. And you produced a statement in response to that notice dated the 4th of December 2022?
Yes, that's correct.
Is the contents of that statement true and correct to the best of your knowledge and belief?
It is.
Thank you. You've got some documents there with you, Ms Harfield. That's right?
Yes.
And I understand, and correct me if I'm wrong, that those documents generally constitute the various exhibits that relate to your evidence.
So some of the documents were provided to me this morning, and I don't necessarily go specifically to those in my statement, but the ones in my statement are also there.
Okay. They constitute the various exhibits that, as I understand it, have been tendered for the purpose of your evidence. Is that right? Thank you. And you've got another document there, I understand, which is a timeline of your various roles within the Department of Human Services. Is that right?
Yes, just because I did a number of different roles and there were a number of sort of iterations, so it was just really to try and get my thoughts in a logical order.
An aid memoir, if you will.
Yes.
Okay, thank you. You are currently the General Manager in the Enterprise Portfolio Management Office of what is now known as Services Australia, is that right?
That's right.
The department formerly known as the Department of Human Services.
Yes.
And you've held that position since the 25th of October 2022?
No, I think July 21, actually.
Oh, it's my notes. Thank you. But previously, you occupied the role of General Manager of the Customer Compliance Division of the Department of Human Services between 14 March 2016 and 30 April 2017, is that right?
Yes, that's correct.
And to be clear, within that period, there was a period that you went on leave between the 16th of February 2017 and the 26th of March 2017, is that right?
Yes.
You joined the Department of Human Services on the 14th of March 2016?
Yes, that's correct.
And prior to that date, the equivalent role within customer compliance was carried out within the Business Integrity Division under Mark Withnell, is that right?
Yes, it was just one division.
Okay. from the point that you commenced in your role in the Department of Human Services, is this right? Mr. Withnell was and continued to be the Senior Responsible Officer for the strengthening the integrity of welfare payments budget measure, is that right?
Yes.
The term Senior Responsible Officer, does that have a particular meaning?
So within sort of project management discipline, it would be the sort of person that is managing most of the aspects of the project. So if there's a technical build, business requirements, design, user specification, the Senior Responsible Officer is there to pull all of those elements together, and you might have several project managers that are responsible for the other sort of specific sort of specialist areas. And depending on the size of a program, you then might have a program sponsor as well. But Senior Responsible Officer is really the sort of main architect of the whole program.
Can you tell us for how long Mr. Withnell continued in the role of Senior Responsible Officer for that budget measure?
So for the budget measure itself, so strengthening integrity of welfare payments had a number of different projects that made up a program. One of those elements was income data matching and the build of the online compliance system. I can't be accurate about a specific date, but really, in terms of the measure, that was going on for a sort of number of years, but it was really, I suppose, focused on the build of the online compliance system. But he was the ongoing SRO for strengthening integrity of welfare payments until it ended, but I can't tell you what date that was.
Okay, and so when you say ongoing Senior Responsible Officer for strengthening the integrity of welfare payments, does that mean he had that responsibility with respect to the build of the online compliance intervention?
Yes.
Okay. And did he continue in that role at least until early 2017, your memory?
Yes, I would say that was, I'd say that was right.
And so within the strengthening the integrity of the welfare payments budget measure, would this be right? That included the scheme that became what is now known as Robodebt.
So it included an element of that. So the budget measures, there were a number of budget measures from, I think, the 2015-16 budget. There was also a number of measures from the MyEFO period, so the mid-year economic period, and each of those measures were going to use the online compliance system, and so together they make up what is known as Robodebt.
Can you give evidence to the Commission as to the extent of Mr. Withnell's involvement in the Robodebt scheme during the period that you were General Manager of Customer Compliance?
So certainly when I first arrived, the budget measure in relation to income matching had already commenced. There had been there was sort of a number of phases. So there had been an ongoing pilot. So when I went, I was briefed on these issues by Mark Withnell and Scott Britton, who was the national manager in the customer compliance division. Excuse me. And there had been a pilot process, which was a sort of known commonly within the department as a sort of rapid response. So it was a sort of halfway measure before the online compliance system went into production. And that had been going since, I understand, since the July of 2015. And during that financial year, the build of the online compliance system was progressing. So the user specifications, the business requirements had been done and established, and the technical build was in progress when I arrived.
So you referred to some briefings from Mr. Withnell and Mr. Britton when you started. So that was in March 2016?
Yeah. So there were and Jason Ryman as well, who was the director of within customer compliance, which really was giving me the background on the budget measures and the requirements and where it was up to, and a sort of, situation view of where the program was up to, along with obviously all of the other work that the customer compliance division needed to do across that year.
And from that point on until early 2017, did you continue to have dealings with Mr. Withnell in relation to what was first the manual intervention that you describe in your evidence, and then later the online compliance intervention?
Yes.
Thank you. You could just bring up on the screen paragraph 110 of your statement on page 30. Call that paragraph up, please. You refer to briefing by Mr. Lumley in that paragraph. See that?
Yep.
Can you tell us when those briefings occurred?
So that would have been when I sort of first, I don't know exact dates, but certainly, I had a number of introductory meetings and briefings with the directors. So Mr. Lumley being one of the directors in customer compliance. And there was obviously quite a focus on the online compliance system because of the requirements around the budget measures.
So around March 2016?
Yes, yeah. Yeah, across a sort of couple of weeks, in sort of, hour slots or whatever it happened to be, yes.
Okay. I just want to ask you about the last sentence in that paragraph. To the best of my recollection, I was not informed or aware of any changes to raising debts connected to the increased use of automation by DHS. Can I just clarify, are you saying that you were not told anything about any changes to the raising of debts connected to the increased use of automation? Or are you saying that, in fact, you were positively told that there had not been any changes?
So my understanding from the briefings was that the difference between what had happened previously to what the online system was going to do was that the online system was there to encourage people to go online and manage the any discrepancy or potential overpayment using the online system, and that was the difference.
Can I just ask you, when Mr. Britton and Mr. Withnell and Mr. Ryman briefed you, did they explain what the manual compliance pilot involved?
I don't remember it in particular detail, but I do know that was what was still happening at that time when I joined.
You don't recall them telling you that it involved a customer being presented with the ATO data and invited to correct it, and if they didn't, the data would be applied?
Yeah, no, that was part of the briefing, yes.
And also, if the customer did not respond, the ATO data
Yeah.
would be applied in an averaged form.
Yes.
and this may seem an odd question, but was Mr. Withnell part of that briefing?
I had quite a lot of conversations and briefings from Mark Withnell, yes.
In which he no doubt referred to the actual process involved at stages, I assume?
Yeah, I mean, it was like a sort of an introduction into, I suppose, the development of the budget measures.
All right, thanks. Thanks.
Thank you, Commissioner. At paragraph 121 of your statement on page 31, you refer to what you describe as 5 iterations of the Robodebt scheme. And you mentioned already the pilot program, which operated at a time that you weren't at the department. You referred then to the manual compliance intervention program. And the point you make is that by the time you joined the department on the 14th of March 2016, that was towards the end of that iteration of the scheme. And then you refer to the online compliance intervention, also known as OCI. You state that was deployed in July 2016 with initially 1,000 compliance reviews initiated. Do you see that?
I do.
And that was, is this right, before the scheme went fully live in September 2016? Is that right?
Yeah.
It was a sort of a testing of the online system.
There was well, what was called a staged implementation, yes.
Okay. And what's a staged implementation?
Well, it was, so with the system itself, so when I arrived, the build was behind time and over budget, and even though it was supposed to go into sort of full deployment on the 1st of July, it wasn't ready for that to occur. The system itself went into production on the 11th of July, and that was where the staged implementation was applied. So rather than the system being switched on and allowed to run end to end with the process, that reviews were initiated through the system but then physically checked to make sure that they were correct before then going to the customer. But once the system went completely live, that check bit didn't happen.
In terms of the checking in this initial phase involving 1,000 interventions, who was doing the checking?
So they would be compliance officers.
Okay. And by checking, what are you describing?
So by checking, it's making sure that the letter that the system produced, which was the notification to the customer, was correct.
Right. And that letter essentially would tell a customer that there's a difference between what the, should say, Social Security recipient had declared to Centrelink and what had been declared about their income to the Australian Taxation Office.
Yeah, so it was asking the customer to go online and confirm or provide more information in relation to that data that was presented in the letter.
And so that would mean, in terms of checking the correctness of the letter, checking to ensure that what was said in the letter about what had been declared about their income to the ATO was in fact had been declared about their income to the ATO. Is that right?
Or whether they had, other information.
Okay, when you say whether they had other information, do you mean other information on the file?
No, the customer.
Oh, I see.
Correct. Could, had a, so in terms of the system, so the customer online can see the payments and then they could correct, if that wasn't correct in relation to them as an individual, they could change that data.
All right, and what were compliance officers checking in relation to that?
So in terms of the stage and implementation, so what they were checking was that the letter was going to the correct customer and that the data that you were asking that customer to check was the data, so that the system was compiling that correctly for that customer to look at.
Right, and by data, you're referring to the ATO data?
Yes.
Okay, thank you. You mentioned that at this time of the staged implementation, the program was behind schedule and over budget. Can you say whether there was any pressure that you felt to accelerate the implementation of the program?
So there was a very, very strong focus on the achievement of the budget measures, particularly from the Deputy Secretary, almost sort of daily sort of interaction about where the system was up to, when the system would go live. As I say, it had been anticipated that it would go live on the 1st of July, which it didn't do. So I would say, sort of when I first joined the department, Mark as the SRO, that sort of would have been more of his focus, and I was focused more predominantly on a sort of broader range of compliance activities. But by the July, the focus was very much on the budget measures and delivery around them.
Okay. I'm going to ask you about the manual compliance intervention program, which you provide a description of at paragraph 126 on page 32 of your statement. If we can bring that up, please. I'm particularly interested in subparagraph A. You could highlight that, please. Can you see that subparagraph A there, Ms. Harfield?
I can.
Thank you. You make this point in relation to the manual compliance intervention program, that apart from the pilot program, this was the first time ATO PAYG data was used as the main methodology to calculate the total amount of income earned by the customer from employment during the relevant period of employment, and multiplying that amount by the percentage of time that the customer received income support payments during the review period. And you say, however, I was not aware of this at the time. I just want to clarify some aspects of this statement so that we're clear in understanding what you're saying. So firstly, when we're talking about the ATO PAYG data, that's data as to income received from the ATO in respect of the relevant social security recipients, correct?
Yes.
And that data wouldn't be data as to actual income earned per fortnight by the customer, correct?
Yes.
Typically, although not necessarily always, it would be for an entire period, an entire year over which the customer earned income.
Yes.
Sometimes it might be for a shorter period. Is that correct?
Yes, I believe so, yeah.
But never did it specify actual amounts earned per fortnight.
No.
And you state this was the first time that data was used as the main methodology to calculate the total amount earned. See that in that paragraph?
Yes.
And by that, would this be right? You're saying that this was the first time that ATO data was used to calculate what had been earned per fortnight using what is known as income averaging. Is that right?
In terms of it being the initiation of a compliance review, yes.
Right.
what the statement does say is it's the first time it was used as the main methodology.
Yes. And so in terms of the words main methodology, is that distinguishing from another method to calculate actual income without first going to the ATO data to calculate that income? Is that what you're saying, Ms. Harfield?
No, I think the difference is that previously a compliance officer would do a sort of end-to-end process in relation to a compliance review, whereas this methodology initiated a request to the customer based on the ATO data. So that was the comparison.
So by end-to-end process by a compliance officer, are you referring to the previous process whereby before a customer was contacted or attempted to be contacted for the purpose of a review, a compliance officer would actually review the whole file held in relation to the customer to ascertain whether there was a discrepancy between what had been declared to the ATO and what had actually been declared by the customer? Is that right?
I don't know that I can say it was that exactly. I wasn't a compliance officer, but as I understood it at the time, or understand it now, was that customers would be contacted in relation to compliance reviews, and then a compliance officer would find the information, whereas this process was saying to the customer, there is a difference between what we have got on a record in terms of the department and what we've been told by matched with the ATO data, and we want you to go online and check that.
Yes.
Can I check this with you, though? You said in your evidence just now that this was the first time the ATO data had been used to initiate a review. But what you actually say in your statement is that it's the first time it was used as the main methodology to calculate the total amount of income earned, which indicates that it's actually used for the first time as the main methodology of arriving at an income figure, not just initiating a review.
So my understanding was that the information for the customer in the department was then matched against the record from the ATO, and based on a number of criteria, that was the trigger to initiate the review. And I'm not...
Okay, but there was
quite
nothing
sure.
new about that, was there? The comparison and arrival at a discrepancy initiating a review.
No.
Right.
But the methodology to then go out and ask the customer to go online to confirm or update.
But Ms. Harfield, that's just not what I'm reading in your statement. It says this is the first time ATO PAYG data was used as the main methodology to calculate the total amount of income earned. Not just about how the customer was asked to respond. And I suspect that would be accurate, wouldn't it? That it was the first time. Anyway, what do you say about?
I'm not sure I can clarify it any further for you. I'm sorry.
Well, your statement's correct, I assume, when it says it's the first time it was used as the main methodology to calculate the total amount of income earned.
Well, I understood that it was the first time that it was used in terms of the volume for the matching, but I appreciate that's not what that sentence says.
Why did you say it? Is it possibly because it was right?
No, I don't. I don't know, I can't tell you the difference between the two.
The difference is evident. It's whether it's initiating a particular form of review or whether it's actually used to calculate a debt,
Yeah.
the income and then in due course the debt.
So it certainly it certainly was used if the customer didn't engage in the process. Yes.
Yes, but what you're saying there is this is the first time that that was used as the main way of proceeding.
Yes.
All right, thanks.
Thank you, Commissioner. And by main way of proceeding, that's to distinguish from a situation that had occurred in the past, whereby averaging might only be used relatively rarely because the compliance officer has undertaken a number of inquiries with the customer, an employer, reviewed the file to ascertain whether or not there is in fact a relevant discrepancy, and use those other sources of information as the primary methodology to calculate the customer's income. Do you understand the distinction?
Yes. Yeah. So I think yeah, in terms of the use of averaging, I think when the way the system was described to me, there was a sense that the initiation that people would engage with the process, and therefore the number of times averaging would need to be used would be less, but that is not what eventuated.
But what I'm just trying to get you clear on, Ms. Harfield, is what you understood to be the main methodology. Sorry, I'll start this again. What you now understand was the main methodology for calculating the total amount of income earned by a customer prior to Robodebt. Understand my question?
Yep.
Okay. And you accept that prior to Robodebt, income averaging was not the main methodology for calculating
Yes.
how much income?
Yes.
Okay. And will you agree with us that, and it's consistent with what you say in your statement, that apart from the pilot program, the manual intervention was the first time that averaging was used to calculate, used as the main methodology to calculate a customer's income? Do you agree with that?
Yes.
Okay. In the last sentence of that paragraph, you say, I was not aware of this at the time. What time are you referring to when you say at the time?
So I think when I first started, in terms of the sense of the budget measure itself, the way it was described and briefed to me was this. I think one of the assumptions that was in the programme of work was that most people would engage with the process.
So when you say you were not aware of this at the time, so firstly, when you say the time, you're referring to that period in about March 2016 when you were receiving briefings, is that right?
Yes.
And am I understanding you to be saying that when the words, I was not aware of this at that time, what is the this in that sentence that you're referring to that you weren't aware of?
Well, what I think subsequently, eventuated was that customers either didn't respond to a letter if they got a letter, or they didn't respond to a notification in their MyGov account. And so the process itself continued on using the ATO data on more occasions than had been anticipated in the programme of work.
Right. So what you're saying you weren't aware of is that in the program, the use of the ATO data um, as the main methodology to calculate the total amount of income in that program as it went on. That's what you weren't aware of. Is that what you're saying?
Yeah, the number of times the requirement for averaging would be used
I see.
was a lot more significant than had been described originally.
I see.
But it had never been used as the default mechanism for calculating debt, had it? It had never been automatically applied to a customer record.
So my understanding in terms of not automatically applied, no, because you would have engaged with a compliance officer, but that ATO data had been used to average previously.
And what was your understanding of how often that had occurred, or in what circumstances?
Well, I didn't, it wasn't, and it was described in the programme similarly that it would be used as a sort of end resort. You know, it was only used where you couldn't get other information.
Where was it described as that?
Well, that was really in my sort of interactions and briefings, and also in the written documentation.
Which written documentation? The sort of presentational briefing documents that Mr. Withnell and Mr. Britton went through with me. Okay, and just so I can understand this, they explained to you it had been used as a last resort in the past and would be used as a last resort in this program.
Yes.
All right. But it became pretty clear, presumably, pretty fast, that it wasn't being used as a last resort, it was being used as the default position.
Yes.
And when did you realise that?
Well, I would say that started to emerge when, in the September, Deputy Secretary Melissa Golightly asked for an increase in the number of reviews that were initiated to get us back in her mind, back on track for the volume of reviews that were required to meet the budget measure.
September 2016.
Yeah, September 2016. And then as a result of those increased volumes of reviews that had been initiated, there were a number of system issues. There were a number of, the sort of level of customer dissatisfaction with the process itself started to emerge, and it started to become clearer that customers were only engaging with the process when they got a debt letter. So the process had sort of flowed through the system. Sorry, I didn't mean to interrupt you, but.
No, that's fine. I was interrupting you, really. But it became clear that the ATO data was being used in an averaged form on these many customers who hadn't responded. Were they the majority, do you recall?
I don't recall the numbers. I know that certainly sort of across the December time that there were lots of sort of, we were doing recovery action with individuals who had, were complaining. So the letter itself that went out to a customer didn't include any sort of phone number for a customer to contact. The direction was to go online. And it emerged through the sort of October, November, December period. As a result of that, customers were taking to social media to talk about the process itself, and there was an increased dissatisfaction with what was happening in relation to the process, and people were receiving debt letters, but having not engaged with the other elements of the sort of process, and at that point. Because there was nowhere to ring, then those were sort of emerging through that sort of social media type environment. And so we were doing recovery action for customers in relation to those issues.
So it was perfectly obvious by that stage then, this is late 2016, that the situation had changed from any concept of ATO data as a last resort.
Yes.
Right, thank you.
Thank you, Commissioner. Do you have any awareness of testing that was done prior to the scheme going fully live in September 2016 as to the number of recipients who were responding at all to the initial letters notifying the customer of the discrepancy and asking them to go online?
I don't have the details of that, but I mean, I do understand that I think Mr. Ryman would have been sort of monitoring some of those things, yes.
It was quite high, wasn't it?
Yeah, it was in terms of, as I say, through that sort of September, October, November period, there was definitely an increase in the sort of dissatisfaction from the customers. And as I say, we also had some systems issues that had incorrectly impacted on customers. So we were doing recovery action in relation to individuals as well as sort of groups of people in relation to some of the payments, yes.
In fact, it was more than half, wasn't it? The recipients who had been sent these letters in the testing phase that did not respond.
Yes. Yeah, yes, I believe so.
Well, to be precise, I think the pilot report in August 2015 showed that 60% did not respond.
Right.
So it was abundantly clear, wasn't it, having regard to the number of customers who were not going to respond, who had not responded in the pilot, that under this scheme, averaging was going to, by default, become the main methodology for calculating these recipients' income, wasn't it?
Well, it was certainly going to be the thing that generated the debt, yes.
And become the main methodology for calculating their entitlement.
Yeah.
Were you aware of a view within the department that those customers who did not respond to those initial letters had in effect accepted the assertions in those letters?
I don't know that I would characterise it as had accepted. I mean, there was certainly, you know, as I say, we were working with customers in terms of the complaints. So if they provided information or a reassessment needed to occur, there was still opportunity to do that.
But I'm talking about customers who didn't respond at all. Were you aware of a view within the department that those customers had in effect accepted what was being asserted in the letters, those initial letters?
Yeah, I don't know if the word is accept, but certainly in terms of the process, that the debt letter would have been generated, yes.
So you would not agree with the proposition, would you, that those customers were accepting what was set out in those letters?
I don't think I would categorise it that way, because I think there was still, you know, it was clear to me, and I did talk to Melissa about it quite extensively, that it was not, the system was not working in the way that the programme had anticipated. And that those concerns, that particularly by the January in 2017, that there was an opportunity to reassess what was happening in real time in relation to the programme of work. But that was not an accepted view from her, and there were changes made to help the interaction and make it easier for customers to get in contact with the department. But the fundamental of the process was not changed particularly, no.
Just going to ask that you be shown a document, Ms. Harfield. It's exhibit number 2703, document ID CTH.30008.0015.7237_R. I'm going to be asking you about the email from Miss Lineker, I think that's how it's pronounced, towards the middle of the page. Do you see that? And we might call it out. So
If by way of assistance, 2703 is tab 13 in the bundle.
Thank you.
Thank you.
thank you.
And just, Commissioner, for the assistance of counsel assisting, the witness has got a list of the exhibits with the tab numbers beside it. So she just takes a moment when you identify the exhibit number to look at that list. You'll find the place in the folder.
Thanks. I've got the same folder, so we can both endeavour to find the right parts.
All right. So, Ms. Harfield, you've got that email there. As I say, I was going to ask you about the email from Ms. Lineker, dated the 8th of November 2016, to yourself, Scott Britton, and someone called Angela Gerdink. Did you see that?
Yes.
Okay. And you recognise this email, of course?
Yes.
You've reviewed it in preparation for your evidence?
Yes.
Okay. You recall receiving this email?
I don't specifically know.
But having reviewed it in the course of your evidence, sorry, in the course of preparation for your evidence, do you recall the general context in which this email was sent?
I believe so, yes.
Okay. And can you tell us what that context was?
So Angela Gerdink, who this is also addressed to, so in relation to AAT cases, so where a customer wants to, I suppose, after appealing in the department, so you could ask for an independent review of a decision for the department, which was an internal subject matter expert that hadn't been involved in the original decision. If the outcome of that was not satisfactory for the customer, they could then take it to the AAT. So this email is in relation to sort of programs. That information would be provided relative to a particular program in relation to appeals. So in relation to the PAYG program, as it says here, that's the legal area providing a summary on what was happening within the AAT in relation to that program.
Can you recall why it was that this summary was being provided to yourself and Mr. Britton and Ms. Gerdink?
Well, it would be to give us information on what the challenges were in relation to the program of work to provide that information. So, and there might be a number of things that would come out of that. So for an individual customer, there might be some recovery process that needed to occur, might need to do a reassessment, might need to do a recalculation, engage with the customer further. And then just really, as I say, to provide that sort of summary about how it's sort of progressing, and given that it was a new program and large volumes, it sort of provides that overview of what's happening.
Okay. I'm just going to ask you about some things in this email, but before I do, I just want to highlight some things in it just to give you the context of my question. So firstly, if we just bring up that part of the email that we were just looking at just a while ago. Thank you. Now there's heading there, current AAT1 appeal numbers. Do you see that? Ms Harfield?
Yep.
And some information is provided about, effectively, statistics about what was happening in the AAT at the time.
Yep.
But what I'm particularly going to ask you about, what I'm particularly interested in, I should say, is that sentence in the last paragraph that's been called out, the words, "It is the case that the AAT1 has recently been more strident in its criticism, but this is limited to a few cases which are unpublished." See that?
I do.
Just as a first point, is there particular significance to the fact that these cases were unpublished from the point of view of the department?
No, I don't know.
Now, if we go over the page to the balance of the email, there's some commentary in the words in italics in relation to what's described as case 3. Do you see that, Ms Harfield?
Yep.
Now, the description of that case in those italicised words describes the applicant in this case as someone who had mental health issues, including Asperger syndrome. See that in the first?
I do. Yep.
And in the next bit down, about the 4th or 5th line, these words appear. The applicant said that when Centrelink was originally investigating this matter, he asked the Centrelink employee to write to him and provide him details of the matter and include any questions that Centrelink wanted him to answer, but his request was ignored. He said he had made a similar request when the authorised review officer was investigating the matter, and that request was also ignored. Do you see that, Ms Harfield?
I do. Yep.
Thank you. And there's further description of the circumstances, but in particular at the end of that paragraph, these words appear. In response to a further question, he said his earnings from Doors Plus fluctuated from fortnight to fortnight. See that?
Yep.
And this, I suggest, is an example of a not uncommon circumstance in respect of social security recipients. That is, that many of them have incomes that fluctuate from fortnight to fortnight. Yeah.
Yes.
You agree with me?
Yep.
And that for such recipients of social security, a calculation of their actual fortnightly earnings using averaged ATO data will clearly be an inaccurate calculation. Do you accept that? Then I'm interested in the last 2 paragraphs and the italicised words. Say the applicant's correct rate of pension in respect of a pension instalment fortnight depended in part on his earnings in respect of that fortnight. The best evidence of those earnings would be his employer's payroll records. Centrelink has the power to issue notices to those employers requiring them to provide those records, and it should also do so with a view to accurately calculating the applicant's correct rates of pension during the period in question. Of course, if Centrelink is unable to obtain those payroll records, it may need to resort to averaging the applicant's earnings over longer periods. Centrelink knows how to properly investigate whether a debt exists. It also knows how to present the evidence it has gathered and the calculations it has made in a way that allows the tribunal to properly review the decision it has made. The decision under review will be set aside and the matter will be sent back to Centrelink to allow it to commence that process. If Centrelink decides to raise another pension debt, the applicant will have review rights in respect of that decision. You see that?
Yes.
Now, if we go to the heading Formal Criticism by AAT1, call that out. You see there, it
Yes.
describes criticism as to the debt raising process with the PAYG program. we just bring that passage back down. Would you agree with me that the central criticism made by the AAT, as per this summary of that decision, was that this particular recipient's income had been calculated using averaging without having investigated whether there were other sources of information available to get a better basis for calculating his income?
Yes.
And would you agree with me that what was being criticised was in fact the default process that was being adopted pursuant to the Robodebt scheme at that time, which was to calculate a social security recipient's income using averaging if the recipient did not respond to the initial letter issued as part of the program?
I agree, and I think that that was, as I say, so when the volume of reviews increased and there were more of these, issues that arose, and not just in the AAT, as I say, it was clear from the media and from social media that there were a number of issues that meant that this system was not working as had been initially conceived, I think is the way to say it. Those were the things that I talked to Ms. Golightly about, because over that sort of Christmas 16 period into the beginning of January 17, I was in contact with Melissa Golightly on an almost sort of daily basis about the issues that were emerging, and by the sort of end of that, the beginning of that new calendar year, I did say to Melissa that I thought that this was the opportunity to really review where we had gotten to, because the assumptions from the program were not being seen in relation to the original sort of perception that you would send an initiation letter and that somebody would go online and look at the data. It was clear that what was happening was that that the process was continuing until the debt was generated, and that's when the customer was engaging, and that was not what had been anticipated.
Right, and by not anticipated, am I correct in summarising what I understand your evidence to be, which is that you anticipated, as had been represented to you by Mr. Withnell, Mr. Britton and Mr. Ryman, that this process of using income averaging would only be used as a last resort, and what was clear even at this time in late 2016 was that it wasn't being used as a last resort because customers were not responding to those initial letters, and income averaging was being used as the default mechanism to calculate recipients' actual income.
Yeah, that's right. And also just the process was one that was clearly not, customers were not able to as easily engage in as had been described in relation to the way that they would. So, for example, customers would be provided with the initiation letter, and if they had requested a customer would indicate their preferred communication interaction. So that might be a letter, a physical letter through the post, or it might be a notification on their MyGov account. But what also became clear is for those initiations that were being put into a MyGov account, that actually, customers who were no longer receiving payments were not actually monitoring that sort of MyGov inbox in relation to the department. So there were a number of things that emerged through that time that increased my sort of concern about the response. And so that was the suggestion about that actually, you know, when the department came back after what they call the reduced activity period across Christmas, that we actually sort of respond in a formal major response way.
I'll come to that period over Christmas shortly, Ms Harfield, but I just want to round out this topic if I can.
Before you do, can I ask one question? There was another issue, wasn't there, with the use of the ATO data, and that was that you would present the customer with the income figure for the financial year and ask them if they had anything to say about it effectively. And there was no explanation as to what would happen next if they agreed with it. So somebody who saw that their income for the financial year had been given as X amount might agree with it because it was correct, without appreciating that it would be averaged across the entire year, so that even if they hadn't worked for, say, 9 months of the year, they would end up with a debt. Do you understand what I'm saying? If somebody
Yes.
looked at
Yeah.
the figures, they might say, that's quite right.
Yeah.
That is what I earned that year. And then the ATO data application would kick in.
Yeah.
So that's another problem besides
Yeah,
non-contact.
no, it was another problem. Yeah.
All right, thanks.
Thank you, Commissioner. The next document is Exhibit 2704, Doc ID CTH.3036.0010.8564_R. This is, and I think it might be tab 14 in your folder, Ms Harfield.
Thank you. Yes, it is.
Okay, thank you. Now, you agree this is another email in this category that we've been discussing of you and others being informed of AAT outcomes
Yes.
and criticism by members of the AAT of the scheme.
Yes.
For example, the summary of case 1 towards the bottom of the page under the heading Commentary by AAT1, if we call that out. Centrelink is responsible for properly administering the social security law. The raising of a debt is a serious matter. Corporations and government agencies make mistakes. Centrelink could have contacted the employer or other third parties requiring them to provide relevant documentation such as payroll records, bank statements and the like. Put simply, it could have taken reasonable steps to investigate the applicant's claim that she had not received any income from the employer. See that?
Yes.
And you'd agree with me that this is another example of criticism by the AAT of the process that was being used, which was to calculate a recipient's income per fortnight by averaging the ATO data without taking reasonable steps to investigate their income.
So I don't know if averaging was used in that particular case. I'm not sure it is clear, but I think that in relation to the budget measure itself, it was clear that the budget measure didn't contemplate seeking extra information. Yeah, that's
Yes.
correct. Yes.
Rather, the fundamental process was the recipient would be sent a letter.
Yeah.
Whether they received the letter or not, if there was no engagement from the recipient with the department, debt would just be calculated on the basis of income averaging.
Yes.
And what was being seen in this and the other examples that you were becoming aware of was that there were significant numbers of recipients whose entitlements were being incorrectly calculated because no reasonable steps to investigate were being undertaken. You agree?
In addition, that they weren't, providing further information, maybe hadn't gone online to actually engage in the process, yes.
Yes, because there, of course, even if a recipient doesn't respond, there are steps that could be taken by a compliance officer to investigate the matter, for example, by contacting the employer, for example.
Yeah, and the budget measure specifically, didn't do that in order to meet the volumes, and I suppose reduce the numbers of compliance officers doing that sort of manual end-to-end type process. Yeah.
And another example of that manual end-to-end process might be a compliance officer reviewing the file to see if there's an explanation for the apparent discrepancy between the ATO data and what had been declared to Centrelink. You aware of that?
Yeah, could have done, yeah.
Would you agree that, at least by this point, it was abundantly clear that the Robodebt scheme was not operating to calculate social security recipients on the best available evidence?
Hang on, that didn't really make sense. You said it was not operating to calculate social security recipients. You mean
Oh, entitlements.
recipients' income? Oh,
Yes.
all right.
Can you just repeat that question?
Would you agree that, at least by this point, it was abundantly clear that the Robodebt scheme was not operating to calculate social security recipients' income on the best available evidence?
I would say that it was clear by this time, and continued in that way, that people were not engaging in the process as it had been designed. I don't know in terms of sort of the individual calculation, but clearly there was more use of the ATO data than had been anticipated, yes.
Well, perhaps you might agree to this, that in cases where the recipient did not respond to the initial letter, there was evidence, there could be evidence other than the ATO data available to a compliance officer in order to calculate a debt. Would you agree with that?
There certainly might have been, but the system, that wasn't the design of the program.
Yes. And in those cases, you'd agree, wouldn't you, that under the system, income was not being calculated with the best available evidence?
Certainly possible, yes.
And to labour the point, if somebody agreed with the figure without appreciating that it would be applied across the year, even though they hadn't worked across the year, the same would apply.
If they hadn't worked across the year, yes, that's right.
And there was nothing in the letters to alert them that that was going to happen. All right.
Thank you, Commissioner. That email can be taken down. I could just take you to paragraph 167 of your statement on page 44. Pull that out. Now, you're referring in this paragraph to those two emails and some other things in that paragraph, is that right?
Yep.
And you talk about the then ongoing pattern of events. You see that?
Yes.
And that this pattern was forming form part of your growing concern that the original assumptions that underpinned the OCI system and process were not manifesting as had been originally anticipated. Do you see that?
Yes.
Okay, and then these issues form part of a conversation you had with Ms. Golightly in January 2017. See that?
Yes.
And we'll go to what you say about that. On page 51, paragraph 190. You say between September and December 2016, you had been dealing with recovery actions for customers as a result of a number of system issues, customer complaints, AAT appeals, and media inquiries. See that?
Yes.
And as a result, you discussed these individual incidents with Ms. Golightly on a daily basis between or during December 2016. See that?
Yes.
You also refer to, during this period, an increase in the number of complaints from customers and social media forums, increased media interest, and requirements to activate recovery action for these customers. See that?
Yes.
Just to be clear, when you say requirement to activate recovery action for these customers, what are you referring to?
So, for example, where there were systems issues and it had impacted on a customer, compliance officers would ring those customers and explain what had happened and that they might receive a letter that says this, but actually what they really needed to do was something different or to contact them. So there were a number of sort of systems issues that had interacted with people's customers' payments, and so there was recovery action in relation to those. The other issues might be where somebody had, sort of made a complaint in social media and you could identify the customer, would be to try and interact with them and resolve the issue that they had.
And in general terms, what were all of these issues telling you about the original underpinning assumptions, as you understood them, of the program?
Well, what it said to me, I think just the sort of sheer volume of dissatisfaction that was, became sort of prominent within the media and social media, and the issues that we were sort of having in relation to the system itself. My sense was that it required a sort of concerted plan of action to resolve it.
But in terms of the assumptions that we've been discussing?
That they weren't. So, that, for example, with the initiation letter with there not being a number on it, the way that had sort of been described to me in my original briefings, and there was a lot of confidence about the measures early on, and they were seen as a success and that there had been, working well in relation to enabling more reviews in relation to social welfare payments.
Sorry, can I stop you? Seen by whom?
Seen by whom? So the team within business integrity that had
Which
developed
is
the measures. So Mr. Withnell as the SRO, Mr. Britton and Mr. Ryman.
Okay, so it was seen as a success because of the number of reviews. What about the fact that people weren't responding?
So this was sort of prior to the online piece. There was a lot of confidence about how customers would interact, and it became clear that that was not how it eventuated. And at that point, it, from my perspective, there was this sense that actually we needed to take stock of where we were and reassess the sort of current situation in relation to the program.
You know what the basis of that confidence was when the pilot had found 60% weren't responding?
Well, there was a heavy emphasis on this sort of behavioural insights concept, which was why the number was not sort of added to the letter. And the system itself, when customers went onto the system, there was a help sort of icon, and if you clicked on the help icon, the help desk number did come up. But actually, what we were seeing was that people were not even going online, and the confidence that sort of was projected to me around the sort of social welfare payments, the sort of described as making sure that the outlays of the social welfare payments was protected and correct, was this sense that customers were used to reporting their earnings information, and this was an online way for them to do it for themselves, and that people would engage with that. But actually, that didn't eventuate.
Had it dawned on you by this stage, and we're talking late 2016, early 2017, that averaging was producing incorrect debts?
I don't know that I would have perceived them as incorrect debts. The way that averaging had been described to me was that it was sort of used in this as a last resort element, and that was something that was acceptable. But what was clear was that it wasn't a last resort.
Okay, but you weren't aware of people saying, but actually I didn't work all that time, so this averaging is wrong? That hadn't...
So certainly where customers were engaging with the process and providing other information, and that was the basis of calculating the debt, then yes, that would have been part of the process.
And just as a sheer mathematical exercise, you hadn't thought through taking somebody's average income over 26 fortnights is not going to be a very reliable indicator of entitlement unless they actually work 26 fortnights?
I don't. There was sort of so much happening at the time. I have to say that wasn't something particularly. I saw it as part of more as an outcome as a result of people not engaging in the process, really, rather than to that as the main issue.
Okay, thanks.
Thank you, Commissioner. So, on the 4th of January 2017, you had a conversation with Ms. Golightly.
Around that date, I don't know if it was definitely that day, but yes.
Is there any reason why you selected the date 4th of January in your statement?
That was the date that we came back physically into the office after that sort of reduced activity period. So that's why I think it was that day.
Do you have a recollection that you saw her on that or spoke to her on that day?
I didn't see her. It was on. She worked in a different location than I did, but I spoke to her on the phone.
Okay. And do you have a recollection that was the day you came back or shortly?
Yes. Yeah.
And you say that during the call, you suggested that given the issues that were being dealt with and the now apparent increased level of customer dissatisfaction, that it would be a suitable time to declare a major incident response to reevaluate if the original measure assumptions were still valid?
Yes.
What is a major incident response declaration?
So where a program or a project, or you might need to initiate a particular dedicated response to a set of issues that are occurring because of the size and the magnitude of them, that you would do that in a particular way. So for example, other types of examples of where you might respond to an emergency, a flood or fires, where actually what you're going to do is bring a group of specialists together to solve the issues that need to be solved around that. My experience of a major response would be as a result of a particular operational incident, or in this case, a sort of number of issues that meant that it was clear that customers were very dissatisfied with the outcomes of the programme.
Prior to this conversation with Ms. Golightly, did you have a conversation with anyone else about whether such a declaration might need to be made?
I don't specifically remember saying that like sort of checking that was something that I would suggest to Melissa, but certainly in terms of contact about what we were seeing in relation to customers. I was certainly talking to, Scott, no, I wasn't talking to Scott Britton at the time because he had gone to NDIS, I think, at that time. But directors, which was really around that sort of recovery action for the customers. So this sort of sense that this was a significant pattern that needed to be looked at.
And am I right in saying that those other directors you're referring to, they were, in general terms, agreeing with you that it was a significant matter that needed to be dealt with?
Yes, and certainly the other general manager that I would have been talking to was Andrew Larkin. So he was the ICT, so responsible for the sort of technical element of the system itself. And also Marcus Markovich, who was in, I can't remember the name of the division at the time, but it was sort of the Debt and Appeals division. And that certainly when we'd physically sort of, Marcus and I worked in the same physical location, and certainly when we returned, there was this view that this needed a more than just normal everyday response, yes.
What about Mr. Withnell? Did you have a conversation with him about this?
Yes, I did speak to Mark in relation to it, yes.
Was that before this conversation with Ms. Golightly?
I can't specifically remember.
Okay. What was the effect of your conversation with Mr. Withnell about this?
So my conversation with Mark was really around the fact that I suppose really just that, again, that conversation about the level of dissatisfaction in relation to what was happening in the operationalisation really of the programme of work, and the fact that it was not really being implemented in a way that had been anticipated.
Or is that a view that he expressed to you, what you've just
No,
described?
that's what I expressed to him.
What did he say in response?
I can't remember a sort of specific one-to-one reaction. I did talk to him about the fact that in terms of the conversations I'd sort of previously had with Melissa Golightly, the Deputy Secretary, that he had more sort of, I suppose, sway in terms of influencing her. And I think that was something that he sort of saw in himself as well in terms of the experience in the department. But I don't really remember a particular conversation. The conversation I particularly remember was the one with Melissa.
But he was familiar with the program and how it was being implemented and understood the points you were making?
Yes. So he was the senior responsible officer from that sort of, I suppose, the development of the program as a whole. Mm-hmm. Yes.
Thank you.
So coming back to the conversation with Ms. Golightly, after you raised the issues you raised, what was her response?
She was very angry that I had suggested that it required a major response, or that there was a requirement to re-evaluate the budget measures at all. And she made it very clear that as the band 3 in the department, it was her decision about whether something would be classified as a major response, and that what I needed to do was make sure that I was able to respond to what she needed me to do.
Did she engage with you at all in the substance of the issues that you were raising with her?
So in terms of my raising, I mean, not in that conversation, no. In other conversations, yes. Melissa's sort of style was to make sure that you had lots and lots of information and lots of detail about each of the particular sort of incidents. The conversation I was trying to have with her at that point was trying to look at it more at a strategic level as a whole, rather than a sense of responding to each individual issue.
Did she engage at any stage with you in this period of January 2017 about the assumption that you had previously understood that averaging would not become the main methodology for calculating entitlement was being falsified in effect?
The focus for Melissa in terms of our interaction, so in that January, there was lots of requests for information and detail. It was to really respond to the tasking that she gave to me and a number of other sort of general managers in relation to what was happening.
But in relation to the specific issue, that it was quite clear by this stage that income averaging was becoming the main methodology for calculating social security entitlements income. Did she respond?
No. In terms of the system itself, what eventuated out of that activity and work was the requirement around adding the helpline number to the letter and providing a sort of fuller explanation in terms of the detail and the content of the initial letter. I believe at the suggestion of the then Secretary Catherine Campbell that people also whose contact preference was by post, that those letters would be delivered by registered post, so that there would be some record of whether those letters had been received.
Okay. And what, if any, impact did Ms. Golightly's response to the issues you raised in your conversation with her on or around 4 January 2017 have on how you subsequently engaged with her about issues that you were seeing in the program?
Well, really from that January, because of the sort of volume of, requests and issues, then really the sort of operating model became one that Melissa might go to a briefing with the secretary or with the minister, and then she would come back and provide a set of actions that needed to be sort of completed that day. She might do that verbally or sort of by email, depending on what was happening. Really between sort of Andrew Larkin in relation to issues for around ICT, Marcus Markovich, Alison McCann, who sort of came in to help and provide some support, Mark Withnell, and a number of other sort of national managers. And in fact, Scott Britton came back from the NDIA. We would sort of just action the work that was sort of required.
After this conversation, on or around the 4th of January 2017, did you raise with Ms Golightly again your opinion that the assumptions upon which the program had been based were being falsified?
I didn't categorise it that way. My sense was that the system, the process that had been introduced was not happening in the way it had been conceived. I wouldn't have categorised it the way you
Well, how you categorised it, did you, after this conversation, raise it with Ms Golightly again?
So in terms of, I suppose, our interactions between that sort of January and sort of mid-February, I had a number of sort of interactions with Ms Golightly, and those would have been in response to information that she had sort of requested. And there was a huge amount of sort of action and activity, and it was sort of happening all across. So my sort of interactions with her were about very sort of specific tasks. We never really had a more general sort of strategic conversation about the programme. There were more people involved in responding, I suppose.
Commissioner, I'm moving on to another topic.
Sure. We will take the morning break and come back at 2:45. Thanks.
All rise. The Commission stands adjourned until 11:45. Royal Commission is now in session. Please be seated.
Yes, Mr Scott.
Thank you, Commissioner. I just want to ask you one last question, Ms Harfield, about term you use in paragraph 190 of your statement. That is the term major incident response, about which we had some discussion earlier before the break. Is that a term that you had some familiarity with in other contexts in your employment history?
Yes, in terms of my sort of background has always been in sort of law enforcement work, and prior to going to DHS, I'd worked in Customs and Border Protection. And so the term major incident response was one that would be used in those contexts where you were required to have a sort of concerted effort and response in relation to an issue or a situation.
Was it a term that at that time, in your experience, had been used within the Department of Human Services?
I think the term used in the Department of Human Services was sort of emergency response, was the way they described it.
And was that term used by the Department of Human Services referring to the same thing in effect as what you're describing as a major incident response?
Yes, that would be my understanding of it, yeah.
The witness please be shown Exhibit 2717, Doc ID CTH.3001.0032.1109_R. I think, Ms Harfield, this might be behind tab 28 of your hard copy bundle. 27, I think, actually.
'28 in mine, but
All right, 28 perhaps, Ms Harfield.
Yeah, no, well, it is behind 27 in my
Okay.
bundle, that email, yeah.
Thank you. Now, you can see there that document purports to be an email chain culminating in an email from yourself to Ms Golightly. Do you see that?
Yes,
Dated the 4th of January 2017. See that?
yes,
Which is on or about the date of your conversation with Ms Golightly that we were discussing before the break.
yeah,
And that email from yourself uses the words Melissa, see below ref methodology.
yeah,
And then it forwards an email from someone called Andrew Chambers. You see that?
yes.
Do you know who Mr Chambers is?
He was a director in the Customer Compliance Division.
Is he one of the directors that you're referring to in your evidence before the break relating to who you were having discussions with at about this time regarding how the scheme was going?
No, I don't specifically recall in relation to Andrew about the scheme, but certainly a number of directors, depending on what the issue was. So I mean, I can't remember how many directors there were, but there were sort of maybe a dozen or more directors in the division. So I was dealing with directors where we were, engaging with customers, who were complaining or, we were looking at doing recovery action. So I'm not saying I didn't with Andrew, I just, it would have been sort of part of the conversation.
Okay. Do you recall receiving this email?
Not sort of specifically. I mean, obviously, I'm aware that there was interaction in providing this to Melissa, but I don't, I don't recall it in the moment on the day, if you see what I mean.
I take it you've had the opportunity to read this email
Yes, yeah.
for the purpose of preparing for your evidence.
Yes, yeah.
Having had that opportunity, can you assist us at all as to the context in which you received this email from Mr. Chambers?
I think after the conversation that I'd had with Melissa, in this sort of sense about providing her with information and tasking, this was one of the things that she had asked for. If my memory serves me correctly, I'd had a conversation with Scott Britton about who might be the most suitable sort of director to ask to sort of provide this summarised description of the concept of averaging within the department, and that was what I was providing back to Melissa.
So am I understanding your evidence to be that this email was sent to you by Mr. Chambers in a context where Ms. Golightly had requested that you obtain for her some information on the use of income averaging in the department prior to the Robodebt scheme?
Yes.
Right, and as a result of that request for information, you sought out information from Mr. Chambers,
Yes.
which he provided by this email.
Yes.
Okay. He says in the first sentence in that email, or he refers to having started in DSS in 1981 and asserts that the concept of averaging income in the absence of detailed information has been around since that time, and I would imagine earlier. Do you see that?
Yes.
He talks in the next paragraph about legislation referring to assessing applying income when it is first earned, derived or received. Do you see that?
Yes.
He then says, however, the practicalities, this is not always known. The choice would be to ignore it. And by ignore it, can you assist us as to what he's referring to there in the context of this email?
So I suppose this goes back to the sort of basis on which the sort of budget measures were developed, was a sense that as a result of what they called the random sample survey, there was a view about the percentage of overpayment that might be occurring against particular payment types, and that the manual process itself was only able to address a small number of those because of the manual nature of it and the length of time that it took, and that the budget measure was there to, I suppose, try and deal with what was perceived as an outstanding quantum of compliance reviews. I think the ignore would be not to deal with that quantum.
Right, and by that quantum, are you talking about the data that was being received from the ATO in the nature of PAYG data?
Yeah.
And then, so the choice that he's referring to is between ignoring that data or applying it in the best way available. Is that right?
Yeah.
Okay. But he then says in the next sentence, note that this is only when we cannot obtain more detailed information. See that?
Yes.
And then he says, averaging income generally, but not always, provides a beneficial outcome for the customer, although this is often quite small. He then says, note that also there are situations where averaging income can disadvantage customers by making the debt amount larger. Do you see that?
Yes.
And then he says, particular care needs to be taken to ensure the earnings are from within the period of entitlement. You see that?
Yes.
And then he refers to the current operational blueprint. Do you see that?
Yes.
Which he says is in the snip below. And if we go over should be over the next page, hopefully.
It's cut off in this version, but he'd given you the hyperlink. Did you have a look at it?
It's actually cut off in my version as well, now that I've got in front of me.
Yes, but at the time, you looked at it, I assumed, in a complete sense.
Yes, on my computer it would have
Thank you.
shown, yeah.
And would you agree that it refers to every
If every possible means of obtaining the actual income information has been attempted, is that what you're...
That's what I'm looking for, Commissioner. Thank you.
Yeah, I'm looking at the actual document, and that's what it says. If every possible means of obtaining the actual income information has been attempted, it is possible to use any evidence available to raise a debt, including an annual figure. So the qualification is if every possible means of obtaining the actual information has been attempted.
So from what you've said earlier, you, I think, agreed that you would have read these words in this snip, and you would have understood that this would have made clear that the practice of averaging would only be applied after every means possible had been attempted first of obtaining the actual information about income.
Except in the design, I suppose, of the measure, it was anticipated that that was the point at which customers would provide that information. So on the system, but it also, in terms of the programme of work, didn't anticipate that compliance officers would request information from employers.
And that would have been a means that was possible.
Yes, but the measure did not contemplate that.
That's so.
Yeah.
So you'd agree, wouldn't you, that it was clear from this document that prior to the measure, which became Robodebt, averaging would only occur after alternative evidence sources to ascertain actual income were investigated by compliance officers. And that by design, the Robodebt scheme didn't require those other means to be investigated.
Yeah.
Also, the point is made under difficulties. If employment is for part of a year only, averaging over 12 months will not result in a correct, averaging over 12 months will not result in a correct result if the customer should have received a full rate at other times of the year. If income varied greatly during the year, and my computer's just dropped out, but the result may be incorrect.
And therefore, that was really why the process was about trying to get the customer to engage with the online and the provision of further information, but that wasn't occurring in a significant number.
So would you agree that what you're being told in this document, that under the process prior to Robodebt, income was calculated using a fundamentally different process to that which was used in Robodebt?
It was still being used where there was no other information, but the circumstance which led to there being no other information was different, yes.
But when you say no other information, are you saying no other information that was available to DHS?
Well, that wasn't separately gone out and sort of sought for, yes. So prior, you know, the process as it was described to me was about you know, they might go and request information from employers, and that part was not part of the new process, no.
Can I point to another thing? This also says actual periods worked should be obtained so that averaging only occurs for periods worked. But this thing was applied under this scheme in circumstances where nobody had actually bothered to determine actual periods worked.
Yeah, and I think, and that was the issue about that. The concept, as I understood it, was that you know, customers would engage in the process and provide that information.
But this would not permit you, in the absence of it, to go right ahead and average.
Possibly not.
Well, it says quite precisely, actual periods worked should be obtained so that averaging only occurs for periods worked.
Yeah, I can only say that that was not how the budget measure was described.
All right, thank you.
But what was, what you had sought from Mr. Chambers was an explanation of how averaging had been used prior to the budget measure, correct? You agreed with me on that point earlier.
Yeah.
And this extract from the operational blueprint you would have understood as explaining how averaging would have been used prior to the budget measure.
Yes.
And as you, I think, agreed in a number of respects, the operational blueprint did not permit averaging to be used in the way that it was being used under the budget measure.
Except that that was the design of the budget measure and that had been approved. So I agree there's a conflict about those two positions, but that is, as I understood it, the way the budget measure had been designed.
That is contrary to how the operational blueprint prescribed.
In relation to what's described here, yes.
Yes.
Yeah.
And what you therefore had been told in this email was that the budget measure provided for a use of income averaging that was fundamentally at odds with the practice that had been used prior to the budget measure.
Yes, and I think that was different from the way that it had been described to me, yes.
Okay, so it was very clear, I suggest, at the time of this email, that effectively what had been introduced by the budget measure was a fundamental change in how social security entitlement for social security recipients was being calculated in reviews under the scheme.
I'm not sure that at the time I got this email and sent it to Melissa that was a view I had formed, no, but I think, in retrospect, that the averaging issue was a significant issue. It just hadn't been anticipated that it would be used in that way.
Can I clarify an answer you gave earlier? Mr. Scott asked you whether or put to you that the budget measure, the way averaging was used, was fundamentally different from the practice that had applied previously. And you said something to the effect of, yes, that was different from the way that it had been described to me. What were you talking about when you said the way it had been described to you, the effect of the budget measure or the way that things had operated previously?
So the way averaging had been described to me was that in the absence of other information that could be applied to calculate the debt, that the ATO information, that the best information that you had available at the time would be used to
As part of the budget
average
measure,
and apportion. Yes,
as opposed to how it had been done previously, although
yes,
in
I
that
think
description
yes.
there may not be so much difference. Thank you.
Um, that document can be taken down. Could the witness please be shown Exhibit 2718, Doc ID CTH.3075.0002.4986_R.
That's tab 28.
Thank you.
Now, have you had an opportunity to review this document prior to giving evidence, Ms. Harfield?
Yes,
Okay. Do you agree that it's an email chain involving yourself on the 27th of January? Sorry, I'll rephrase that. An email chain involving yourself on the 4th of January 2017.
yes.
If we just call out the email at the bottom of the page that goes from the middle. It's an email from yourself to Ms. Golightly, CCing others. Do you see that?
Yes,
Okay. Day of the 4th of January 2017.
yes.
Okay. The CCs include something called exec.ccd. What's that a reference to?
And that's sort of like a tasking coordination type administrative team.
Right. And what, from the name of it, exec.ccd, does that have can we infer what team that was?
In terms of who was in the team. So I think it was sort of one or two, maybe three people by this point that were sort of trying to manage the requests that were coming in for information and data and taskings. So it's like that sort of support team.
Okay, so you can't assist us as to who was in that team.
Oh, as individuals, I think it was Jenny Spokes and Jonica. I can't recall her surname, but yeah.
Can you assist us as to why they would have been CC'd to this particular email?
Not specifically, no.
Did they have any role in relation to providing information to the Secretary of the Department at the time?
I don't know. I think I'd have to look at who was in the group email.
Okay, well, can I just ask you to read the email to yourself without reading it aloud so you're satisfied yourself as to its contents? Now, you see the first sentence, it says explanation of assessment methodology, in round brackets algorithm.
Yep.
And you'd agree that the email, in a general sense, provides a description of the process that was used in the online compliance intervention.
Yep.
Just in relation to the sentence about the middle of the email commencing, the methodology for assessing and calculating a debt has not changed. Do you see that?
Yep.
Would you agree with me, based on your earlier answers, that statement was false?
At the time, I understood that the way we were assessing and calculating the debt had not changed. That it was about, that the issue, in my mind, of the system was more about the customer not interacting with the process.
Well, a full sentence says the methodology for assessing and calculating debt has not changed, and averaging is only used where the customer does not provide the detailed information.
Yeah.
It was clear from the earlier email I showed you involving Mr. Chambers that it wasn't sufficient under the previous process to engage in averaging simply because the customer didn't provide detailed information. Do you agree with that?
Yeah, I think at the time that that was not, I hadn't made that connection.
I suggest it was obvious to you from that earlier email involving Mr. Chambers that the statement that the methodology for assessing and calculating a debt has not changed was false.
Yeah, I mean, that was not how I thought about it at the time, no.
But it was also the case that, as you understood it, you'd moved from a last resort position to a substantial proportion of the people approached having averaging applied
Yes,
automatically.
yes.
So that's a change, isn't it?
It is, and it wasn't as had been perceived in the budget measures, and I think that was the reason for, trying to re-look at what was actually occurring. But the focus was very much on making the changes to how we were interacting with customers and changing the sort of customer experience of the process in order to get the information so that the debt could be calculated.
Yes, but it means that the method for assessing and calculating a debt had changed from a last resort position to an automatic application in relation to a substantial proportion of customers simply because they hadn't responded. So that does make that statement untrue, doesn't it?
Yeah, I'm just saying, I think at the time I wrote it, I hadn't made all of those. I didn't think it to be an untrue statement when I wrote it in an email.
If we just go to the email at the top of the page, call that out. That purports to be an email from Ms. Golightly to a number of people, including the Secretary's office. See that?
Yeah.
It's the same date as the date of the earlier email.
Yeah.
You agree that this is an email forwarding that earlier email with some additional commentary from Ms. Golightly?
Yes.
Okay. And the words are, please find below an explanation of how the algorithm is used and how long it has been in place. I understand Min Porter needs this info by 3:30 p.m. See that?
Yep.
Can you assist us by reference to those words, what the purpose of this email of Miss Golightly, CC to yourself, was?
No.
One might think there was some pressure coming from the Minister's office because he was having to respond to media queries about this averaging process and the department was being asked to justify it. Would that be a fair inference?
That might well be the case. I mean, Minister Porter, I think, was the minister while Minister Tudge was on leave.
He was Minister for Social Security, but he was also stepping in to act in the Human Services role at the time. And a ministerial inquiry of the department is something that everybody jumps to. Would that be a fair thing to say? And here was the pressure on about justifying averaging because he was having to explain it. Is that also fair?
It's certainly an explanation.
Did you feel yourself in a situation of some pressure to help in explaining?
I mean, I think from that whole sort of December through January time, there was a huge amount of pressure in relation to responding to multiple requests and inquiries and responding to sort of customer issues and really sort of the scrutiny of every sort of element of the implementation. So staff were working really very long hours without any sort of break or rest, and this was sort of one of those. It reads to me that it was one of those sort of elements that we were trying to deal with and respond to. Yeah.
Do you recall that about that time there was significant criticism in the media about the way debts were being calculated under the Robodebt scheme?
I certainly recall there was a lot of attention just to every sort of element of the scheme, which would have included the calculation of debts, yes.
And do you recall that there was a consistent message that was advanced by the government and the department that there had not been a change in how debts had been assessed and calculated under the scheme?
Yeah, and as I say, that was the way that it was described to me.
But you could see it wasn't the way it was happening.
I agree, sort of look at the documentation in this way, but it was sort of a frenetic period of time, and I don't recall really at any point thinking that the application of the averaging was, I suppose, the sort of element, the sort of pressing legal element. For me, it was much more about that the system was not working as intended, and we need to, sort of reassess that. I understand that averaging is sort of part of that in terms of the volume, but for me at the time, it wasn't the one thing. There was a whole lot of issues happening all at the same time.
Okay, but when you're responding to this email, the focus is on averaging.
Yes. Yeah, no, I'm not disagreeing with that.
Did you feel under any expectation at all in providing information to Ms. Golightly in relation to the practice of averaging to provide her with statements to the effect that there had not been a change in the methodology for assessing and calculating a debt?
In relation to the sort of description, I, did, because it was about what happened in the past, it was sort of based on, I suppose, the subject matter experts in the division at the time, and obviously I was keen to respond to tasking and action and activity, but as I say, just in terms of the sort of volume, there was lots of sort of questions, and yes, as a division, we were doing our best to respond to all of them.
Either
What
on
about
the...
this, sorry, what about this particular issue, though, to convey that there was nothing new in the way averaging was being applied? Did you feel under any pressure to provide something to support that notion?
I don't, not sort of under pressure, it was just, that was genuinely my understanding. That was how it was described to me.
By whom?
Sorry, Mr. Scott, but I thought we'd agreed that the way averaging was being used, it became apparent by about September, was that it was now a default mechanism which was applying to a great number of people who'd either agreed with the figures or not responded, whereas you'd been given to understand it would just be a last resort.
So in terms of the numbers of people that it was applied to, the concern was that that was a lot more people and it was no longer a last resort, but the way that averaging was sort of calculated and applied was not different.
Well, it was applied automatically, whereas in the past, as we've seen from the operational blueprint, it was a matter of investigations being made as to
Yes.
what the situation was.
Yeah.
So there's an obvious change, isn't there?
Yes, in terms of, yes, I'm not really articulating myself very clearly, but it was more about the volume and the numbers of customers that it was being applied to, in my mind, was the issue.
Well, that's hard to understand because it wasn't just about the numbers, it was about the way you did it, wasn't it?
Well, I think in terms of the information, I still had this sense that the way it was described to me was that the sort of application of the calculation had not changed in the way that averaging was applied.
Including to people who hadn't responded or who had taken the figures as correct. That had never been the case in the past, on your understanding, had it?
No.
All right.
So the circumstances in which it were being used were increased, yes.
All right. Mr. Scott?
Thank you, Commissioner. Just to be complete about the matter.
Oh, sorry, before you go on from there, I want to ask you about the second last sentence in your email. There's provision in the Guide to Social Security Law to enable averaging of income to occur. Had you looked at the Guide to Social Security Law?
At that point, no, that was a piece of information that would have been supplied to me.
From whom?
From one of the directors.
You see, there was an operational blueprint, which is a DHS thing, I think. It's not the Guide to Social Security Law, anyway. Somebody told you that the Guide to Social Security Law said averaging was okay, do you say?
I would assume that's why it's in there, yes.
I don't suppose you could point us to anything in the Guide to Social Security Law that said that?
I not immediately, no.
And you hadn't looked for yourself?
I don't believe so at that point, no.
Okay, thank you.
Thank you, Commissioner. Just finally on this email, Ms Harfield, reflecting on that phrase, the methodology for assessing and calculating a debt has not changed. Do you now accept that phrase is inaccurate?
Yes.
Thank you. That document can be taken down. Can the witness please be shown Exhibit 2735, Doc ID CTH.3023.0006.7608_R. Should be tab 46, I think, in your material, Ms Harfield.
46.
Yes, I think so.
No.
Tab 44, I'm told.
44.
Apologies.
No.
If it's any use, it's 47 in mine, but
Commissioner, I'm not sure that you and the witness have exactly the same
no, I don't think we do.
folders.
But I thought we were only about one out, so
I think it shifts about depending on whether you've got prior exhibits in your bundle, the witness has hers in a separate bundle.
see, thanks. Anyway, do you think you found it or not?
Could be an email chain.
Yes, I've got it, sorry.
Okay.
Got it. Thank you. So this should be an email chain culminating an email from yourself, simply with the word Scott as discussed. See that? Out of the 15th of January 2017.
Yep.
And that's forwarding an email from yourself to Ms. Golightly on the 13th of January 2017. See that?
Yep.
Now, you recall reading this email in the context of your preparation for your evidence today?
Yes.
So the first words in the email, Melissa, as requested, please find a simple explanation for DSS reference explaining that the methodology to assess employment income has not changed. See that?
Yes.
Can you assist us at all as to the context in which you sent this email to Ms. Golightly?
I believe that this was in relation to a request from Miss Golightly for a sort of, I think the wording was something like a sort of plain English simplified version of the processes and how they had changed across the time and the application of the methodology.
The words explanation for DSS reference, can you assist us what that's referring to?
No, I don't.
Do you think that perhaps that the explanation that was sought by Ms. Golightly was an explanation to be provided to the Department of Social Security, Social Services, I should say?
I think more likely that it might have been a meeting that maybe she was attending and wanted some information, but I can't recall specifically, sorry.
And so the balance of the email would have been for the purpose of informing her to enable her to provide information to the Department of Social Services. Would you agree?
Possibly, yeah.
All right. So first of all, the opening words let's say, please find a simple explanation explaining that the methodology to assess employment income has not changed. See that?
Yes.
So those words, I think you'd agree based on your earlier evidence, that is, the methodology to assess employment income has not changed, are inaccurate.
Yes.
Then we just call out what's in italics immediately below those words. It says, in respect of the current online compliance system, there's been no change to the methodology used for the assessment of employment income. You agree that's an incorrect statement?
Yes. And as I say, it was the way that it was described to me. But I agree that it's incorrect.
Right. Remains the same and has been used for many, many years. An individual is required to report their employment income fortnightly and it is applied to the period worked. Do you see that?
Yes.
And then the next words are, the averaging of employment income over the period worked is only used as a last resort if other information is unavailable. You see that?
Yes.
Now, you would agree, wouldn't you, that last sentence I've read out is also inaccurate.
Yes.
Under the Robodebt scheme, averaging was not being used as a last resort, was it?
No, and this was part of the conversation, as I say, that I had with Ms Golightly. You know, that the proportion of people not engaging with the system was significantly higher than had been anticipated, yes.
But regardless of the proportion of averaging being higher than anticipated, in any event, for those where averaging was being used, it wasn't being used as a last resort, was it?
No.
And that's in contrast to the process that had previously been adopted where it was used as a last resort, correct?
Yep. I mean, before my time in DHS, but yes.
All right. And if we just call out the section under the heading previous process,
Yes.
that first bullet point identifies a number of steps that would, under the previous process, have been undertaken before resort would be had to income averaging, correct?
Yes.
So it's plain, isn't it, on the face of this email, that the statement in italics just above, that averaging was only being used as a last resort, was false.
So I think that the way, so within the budget measure, the process, it was anticipated that the department would no longer go to employers to seek the information. So that was clear in the application of the measure itself. But as I say, in the way it was presented to me is that it was an online version of what had happened, but that the emphasis was more on the customer to provide the information rather than the department to go to the employer to get the information.
It wasn't just a matter of emphasis, it was a change. You didn't go to the employers, you just asked the customers and you looked no further.
Yep.
In fact, at this stage, compliance officers weren't even looking at the file.
No.
That document can be taken down. Can the witness please be shown Exhibit 1263, Doc ID CTH.0033.001.0516_R.
Got any idea of the...
The witness might be assisted. They should have a pink tab on the side, 121, was it 1263?
Yes, it is.
In the second folder, yes.
Yes.
You'd agree with me, Ms. Harfield, that this is a minute addressed to the Secretary of the Department of Human Services.
Yes.
You've had an opportunity to review this document in preparing for your evidence?
This morning.
Okay. And you'd agree that it refers to a then employee of the department, Colleen Taylor?
Yes.
And concerns that she had raised in relation to the changes in the department's compliance program.
Yes.
It states that you and someone called Mr. Hudson then met with Miss Taylor on the 8th of February 2017.
I think it might have been the 9th, but because I understand in my calendar, that's when the calendar invite was, and it wasn't a face-to-face meeting, it was a telephone conference type call.
Okay. And then it says that you subsequently actually met her in person during an office visit on the 13th of February 2017.
Yes, that's right.
Okay. Now, if we go over the page, at the bottom, there's a summary of attachments.
Yep.
Did you, by the way, prior to reviewing this document today, have you seen this document before?
I don't remember seeing the minute, no, but I think when this was, it's signed on the 2nd of March by Alison McCann as acting general manager. So I believe I was away at the time.
Oh, okay. But do you recall having a meeting, you recall speaking to Miss Taylor?
Yes.
And then the meeting
Yes.
referred to? Now, just in terms of the attachments, attachment C is described as email correspondence from Miss Taylor to Secretary. See that? I'm not going to the attachments themselves yet, I'm just that section.
Oh, sorry.
The summary of attachments, it says email correspondence from Miss Taylor to Secretary. Do you see that?
Yes.
Okay. We go to Exhibit 2532, Doc ID CTH .2009.0007.5968. Should be an email from Miss Taylor addressed to the then Secretary, Miss Campbell, dated the 7th of February. You got that there, Miss?
Yes.
And CCing Mr. Yongan.
Yep.
Have you seen this email before?
Yes.
Had you seen it before you had your conversation with your teleconference with Miss Taylor in early February 2017?
I'm not sure if I had seen the covering sort of email. I know that in terms of the sort of content and issues that had been raised, there was a meeting with the Secretary, Ms Golightly, Mr Hudson, Annette Mussolino and myself, which discussed some of the issues that were raised, and then that was what prompted the action to have the meeting.
Okay, in terms of the issues raised by Miss Taylor, you'll see that the email refers to attachments. Attachment 1 is response to the Secretary. See that?
Yep.
And hopefully the next document in your bundle is Exhibit 2533, Doc ID CTH.2009.0007.5969. Should be what purports to be the response to the Secretary document.
Yep.
Okay. And so at this meeting that you mentioned involving Ms Campbell, I think you said Ms Golightly, Mr Hudson, Ms Mussolino, at the time of that meeting, had you seen this document that you're looking at now?
No, I don't. I think that meeting was. I'm not sure if it had been sent to me prior to the meeting to talk about at the meeting, or I'm not quite sure which, but.
Am I understanding your evidence that you did see it at some stage prior to the conversation with Ms Taylor?
Yes, certainly before I spoke to Ms Taylor.
Okay, but you recall the meeting with the Secretary and others?
Yes.
Prior to the discussion?
Yeah.
With Ms Taylor. Can you tell us what was said at that meeting and by whom?
I think there was a sort of, if in relation to, I suppose, what had prompted this email to the Secretary, Catherine Campbell, was there was a sort of growing view in the agency, and staff were obviously concerned about what they were seeing and hearing in the media. I think Secretary Campbell had put out a sort of an all-staff style sort of message. I can't remember if it went to all staff, but a message that was sort of based on a sort of reassurance that you know, the department was aware of the issues and that people should you know, provide any information to her that they wanted to, and as I understand it, that's what had sort of prompted this from Colleen Taylor, and the conversation was about in the meeting sort of going through the areas of sort of her that she had raised as a concern.
And, okay, so there was a discussion going through the concerns that Ms Taylor had raised, is that right?
Yes.
Okay, and who, do you recall who identified what those concerns were during the meeting?
I mean, not sort of specifically in terms of which individual said what in terms of recounting that as the meeting, as a sort of, you know, part of all of the information and responses that were sort of required. It was sort of mostly led, I would say, by Ms Golightly in terms of responding to the issues that were emerging as a result of the programme.
Okay, so what did you understand from this discussion? What is the issues that had been raised by Ms Taylor?
So the issues around sort of ease of access, the customer experience, the fact that you know, a number of staff had sort of highlighted that if people didn't have an active MyGov account, that made it very difficult for them to engage with the process, that those were some of the issues that sort of were coming out. I understand from the sort of description that these were things that Ms Taylor had sort of raised prior to the implementation of the budget measures, some of these issues, and that she was sort of repeating those concerns that would have been made in the early sort of 2016 period. And as I say, and I understand this sort of conflict really around, on the one hand, being described as you know, an appropriate use of averaging. You know, my understanding was that the application of averaging could be used, but that is one of the issues that obviously she raises in that. So I think that was the sort of general tenor of the conversation, and obviously a view to provide Ms Taylor with an opportunity to talk about those things in more detail.
So am I right in understanding your evidence that the description at the meeting of the issues that were being raised by Ms Taylor was that she'd raised issues about whether the use of averaging in the OCI program was appropriate? Is that right?
Yeah, I think that's how it comes across in the issues that she describes is one of them, yeah.
I'm just trying to be clear about how the issues were described at this meeting.
I don't know that I can give you any more specific detail. As I say, it was within that sort of period of time, there was just a huge amount of sort of information required, and I can't pinpoint in more detail the conversation in that meeting.
But even in a general sense, can you tell us whether it was identified in the meeting that Ms Taylor had raised issues about the appropriateness of averaging as it was being used in OCI?
I can't tell you if exactly those words were used in the meeting, but certainly in terms of the concern about the application of averaging, there was conversation about that. And again, my understanding of the meeting was that in relation to the budget measure, there was not a concern about the lawfulness of that.
When you say there was not a concern, are you saying there was no concern expressed, or are you saying that people at the meeting expressed that they understood that there was no difficulty?
Yeah, the latter, that wasn't an issue, that certainly the issues around access to MyGov, the notifications, it was much more at that sort of practical level, the ability to have the phone number in the letter. So some of those things were already sort of in train for changes in the way that the process was happening.
But in what she'd sent to Ms Campbell, which you'd seen, she made the obvious point that the PAYG data was unreliable because employers would report an entire financial year, and you needed to know before you could do anything with it what the actual work periods were. That was in her email, and that was no longer being ascertained.
That's the content of the email.
And what she's saying is entirely consistent with the operational blueprint, which said that actual periods worked should be obtained.
Yeah.
Well, did it occur to you that she was perfectly right?
I think really at that point, I'd raised some of the issues, and I understand that there's this sort of sense that in terms of averaging, but for me that wasn't really the focus was on the volumes and getting people to engage in the process, and that was the focus. I think in terms of sort of the legal question, that was something that from my perspective was happening with Miss Golightly, and Ms Mussolino and the secretary. I wasn't really, I think, involved in that sort of element of it.
But she wasn't talking about a legal question. She was saying that the PAYG data, she used the expression, the payment summary data is corrupt for our purposes. And she explained what she meant, that employers would just give a financial year, and you couldn't know without finding out when the person had actually worked whether that was any use. Well, did it not strike you? That's right.
I mean, I think in the sense that these were issues that had been raised sort of previously, and as I understood it, sort of dealt with. The budget measure was the budget measure, and it was implemented as described in the budget measure.
So even if she was perfectly right, nobody was going to listen to her.
Well, certainly in terms of some of the issues that she raised. I mean, I did spend I did go and meet her face to face. I also met with the staff, and the concern there was really about the shift from the process where which I've sort of described before, which was that they would engage with the customer and then sort of provide a service almost in relation to getting the information and calculating the debt, and that was a process that might take some significant amount of time, and that the concept within the agency prior to my sort of arrival was how to deal with the compliance reviews that were not dealt with in that process, because that process sort of took so long and therefore the number was limited, and that the online system was a way to do that.
Mm-hmm. So if anybody pointed out the flaws, it didn't matter because that was the way it was going to work?
Well, there certainly was a focus on keeping it going, yes.
All right.
Why is that, given, as you indicated in your evidence, by the end of 2016, you were of the view that the assumptions underpinning the program were in question?
Yeah. My position wasn't accepted. It was, the focus was on achieving the review numbers as described in the budget measure. In terms of sort of the compliance division, really the compliance division was the division that was implementing the sort of, or putting into effect what was required from the budget measures. So the OCI system was developed in order to be used across a number of different budget measures. So in some senses, that sort of design, user spec, the way it was going to work had all been developed for the employment income matching piece. And so as I say, the focus was not on revisiting or reviewing or questioning the outcome. The focus was on achieving the numbers of reviews, which was linked to the savings that were articulated in those budget measures.
I just direct you to the quote from the Secretary's message that's referred to there, at the top of the page. And see the words in bold. There have also been no changes to how we assess income or calculate and recover debt. See that?
Yep.
And then further down the page, the third paragraph in red, there has, underlined, been a very dramatic change within the last 18 months to the way in which compliance assesses income and calculates and recovers debt. Do you see that?
Yes.
And that statement was plainly correct, wasn't it?
Well, at the time, I don't think that was the view, and it was certainly not the view that was expressed. I mean, I recall, in particular, in relation to the Secretary and Melissa and Mark Withnell, that the sense that the assessment was still a valid and appropriate assessment. But I do agree that's not the way Colleen describes it. It just, the measure was adopted, and this was the methodology to implement it.
But when she said there was a dramatic change, she explained how
Yes,
there was a
no,
dramatic
I'm not.
change.
I'm not.
And she was right, wasn't she?
Yes, and I'm not saying she was wrong, but it wasn't at the time. It was not sort of accepted
Well, why not?
that was the case. I don't know.
Perhaps, Commissioner, I note the time. I've got a few more questions on this topic.
I'll keep going, and if necessary, we'll take a shorter lunch break because I know there's another witness this afternoon.
Yes. So in the subsequent meeting, in the subsequent conversation you had with Ms Harfield on or about the 9th of February 2017.
She is Ms Harfield.
Sorry, with Ms Taylor on or about the 9th of February 2017. Would you agree that Ms Taylor explained the concerns that she articulated in this document that I've been showing you?
Yes.
And did you say at the end of the call something to this effect, that to you it sounded like the approach that had been taken previously, that is prior to the Robodebt scheme, was time-consuming and laborious, and now everything under the new scheme would be quicker?
I don't recall those particular words. I mean, I do recall having a conversation about that this was an adopted, budget measure. It was something that, as public servants, we were implementing in line with its requirements. I don't know that I don't recall those particular words.
You say you don't recall those particular words, but is it consistent with your recollection of what you took from the meeting with Ms Taylor?
In terms of those specific words,
yeah. Well,
it doesn't sound like words I would say in that way. No.
Well, did you take Ms Taylor to be primarily complaining about how time-consuming and laborious the previous process had been, and that now everything would be much quicker under the new process?
No, my sort of conversations with Colleen was much more around, I think, trying to respond to her concerns about the sense that it had moved from a compliance officer carrying out the end-to-end sort of process, which could take a significant amount of time, and that the budget measure was about trying to have an expanded coverage across what was seen as potential compliance issues against the payments.
Right. So how did you respond to those concerns?
So when I came to Brisbane to meet with her, and I don't know if I met before with other sort of groups of staff, but I did sort of obviously interact with compliance officers that were working in relation to the online compliance work, and I think that was really around sort of a reassurance piece that we were listening to their concerns in around like the helpline and the changes that had been sort of made to the system in that early part of January 2017.
By helpline, what are you referring to?
So previously I talked about that the initiation letter didn't have any contact number in it, and that decision was as a result of the behavioural insights piece of work that meant that to encourage people to go online, if you put a number in the letter, more people would ring. So there was a decision by the project at that time for the number not to be in.
So you talked to her about that in this conversation, is what you're saying?
Yeah, we talked about the changes that had occurred in that sort of January period in response to some of those concerns. Yeah.
None of which involved reverting back to the old process of using averaging as a last resort.
Not the old manual process, no.
But in any event, none of the changes made in January 2017 reverted the process to using averaging as a last resort.
No, it was all about trying to get more people to engage in the process to provide information.
Right. So you talked to her about changes that were made in 2017. What else did you talk to.
What we were talking about your discussions more generally with compliance officers. I thought you were saying you'd spoken to a lot of them about these concerns.
Yeah, and so it was a bit of both. So it was, I spoke to Colleen sort of separately because, of course, she had written to the secretary, and I think as part of our telephone conversation in that sort of early part of February, I think it was. So I think the 9th, but I think the minute says the 8th. That because I was coming to Brisbane, that it was agreed that I would, sit down and talk to her face to face.
Okay, but she wasn't unique. Compliance officers across the country were raising issues about averaging, producing incorrect figures, weren't they?
I don't know that they were raising issues about averaging. There was a concern about the response of the community in the social media and in the media, and it was to provide the staff with a view about what changes were being made, but also, the fact that the department, from Melissa's perspective, was that the budget measures were going to progress the way that they, with these changes, but that the budget measures would continue to be
So,
progressed.
like it or not, this is what you've got. Is that the effect of it?
I don't know that it was like from my perspective that's not the way I would talk to staff. I mean, there was a sense that if we could make changes and make improvements, those would be listened to. But in terms of the department's decision about delivery of the budget measures, they were continuing. Yes.
Just one last series of questions about your interaction with Ms. Taylor. Would you have, in this telephone conversation on the 9th of February 2017, engaged in any discussion with her in which you sought to justify the new process by contrasting how efficient the new process was compared to the old process?
Not in those terms, no, that doesn't ring a bell.
Okay. In any terms?
Well, we did talk about the fact that the old process, that the budget measures was about a focus on that perception of outstanding reviews that needed to be covered, and it was about trying to get through more volume, yes.
All right. After your telephone call with Ms. Taylor and your subsequent meeting with her, are you aware of any action that was taken to examine the merits of her concerns regarding how averaging was being used in the online compliance intervention?
No, I'm not aware.
Okay. Commissioner, I am moving on to another topic. I think another half hour with this witness.
Okay, that being the case, we might come back at 2:15. Well, how long do you think you'll be with Mr. Lumley?
Not as long as this witness. I think perhaps a bit over an hour, maybe a little bit longer than that.
Look, just to be on the safe side, I think we might come back at 2:15.
Certainly, Commissioner.
Rather than 2:30. Thank you.
All rise. The Commission stands adjourned until 2:15. The Royal Commission is now in session. Please be seated.
Look, there's just a minor thing I wanted to check with Ms. Harfield. It relates to that email of the 15th of January, which you showed her. The one that begins as, or has the section that says, as requested, please find a simple explanation. Do you know where we can find that?
I think the email, Commissioner, that you're referring to is Exhibit 2735, doc ID CTH.3023.0006.7608_R.
And it's tab 44 in the witnesses bundle.
Okay, thanks for your help. I don't think it's 45 and 44 in my book,
I'd
unfortunately.
be 47, Commissioner. And yours.
Yep, that's it. Look, I just wanted you to look at this version of your email, which, oh, sorry, it's not a version of your email. It's an email which you sent a little later, I think. But it has the same, that same statement. And the only difference that I can see is at the bottom it says, as per the Social Security Act, bracket part 3.6 benefit rate calculator. But if you want to have a look, and I'm sorry, I've only got the one hard copy, Ms. Hogan-Doran. Jess, could you show that to Ms. Harfield?
Thank you.
I was just puzzled why you would send it twice, and I wondered if you could shed any light.
It might have been in response to a further question, but I don't recall.
All right, thank you. Look, I'll make it an exhibit for completeness since I've asked the question. And if you'd retrieve it, and I'll just get it shown to Ms. Hogan-Doran so you can see what I was talking about.
Thank you, Commissioner. Is that an email from Ms Harfield?
Yes, it is, and it's really in almost identical terms to the one she was looking at, but it only contains that one passage and it's got an extra entry at the end, that's all.
And that's from 2:58 p.m. and the one that she was taken to before the adjournment is at 4:09 p.m.
Okay, so I've got the order reversed. But anyway, you might like to take a note of the document number.
Oh, no, it's actually on a different... That's confusing. So this one is on the 15th of January and the other one is on the 13th of January, so it's...
Oh, okay. So it's actually 2 days later,
It's later, yes.
but you can't, that doesn't help.
No, sorry.
All right. I will make it exhibit 2808, if that's all right with the solicitors assisting, or you wouldn't like an A on that or anything? Okay, thank you. Yes, Mr. Scott?
Commissioner, just in relation to that document, Ms Harfield, do you still have it there?
No, it's here, but we can put it in front of Ms. Harfield.
Thank you.
Can you see one of the addressees to the email as someone called Serena Wilson?
Yes, I can.
Do you know who Serena Wilson is?
I believe Serena Wilson was a Deputy Secretary in DSS at the time, possibly.
Can you enlighten us at all as to why this email would be sent to Miss Wilson?
No.
All right. Well, having regard to the words in the email from the 13th of January, which you were taken to earlier, which used the words, please find a simple explanation for DSS reference, and given that this email, this subsequent email on the 15th of January is addressed to one of the addressees is Miss Wilson,
Yeah.
would you accept that the email is purporting to provide an explanation to DSS of the methodology to assess income under the Robodebt scheme?
Yes, and as I say, my sense would be that it was as a further request.
So it may be that Ms Wilson wanted some reassurance.
I mean, I really don't specifically recall, but I've sent it back to Melissa as well and addressed it to Melissa. I don't particularly recall why Serena Wilson is also in the sent to address, but she is.
Yes. Were you aware that all this was in the context of an ombudsman's inquiry? And when I say all this, I mean that whatever was going on at this time in January was at a time when there was an ombudsman's inquiry.
Yeah, so there were a couple of things happening with the Ombudsman in terms of responding to Ombudsman's requests. So in relation to individual cases, there was provision of information about individual customers. There was also provision of information in relation to requests from the Ombudsman in responding to their own motion inquiry. And I also believe that the other thing that was happening at the same time was a Senate inquiry, but I don't know specifically what this request was in relation to.
If I tell you that Ms Wilson gave evidence that there was a meeting on that day, or it might have been a teleconference, between staff from DHS and DSS, which included you to brief her. Do you remember that?
I don't particularly. I mean, I know it was a Sunday and we definitely were sort of working really every day and sort of long hours, and there was a lot of meetings and interactions. I don't specifically remember that meeting, no.
And do you remember in interactions at that time, Ms Golightly saying income averaging was just being used when there was no other information available?
I don't particularly remember her saying that specifically, no. I mean, I don't recall the meeting or people at that meeting.
All right, thank you.
That be handed back, please.
Just to put it in context, and that I'm not suggesting Ms Harfield was available for this, my note of Ms Wilson's evidence was that Ms Golightly assured her after the meeting there'd been no change to the way that DHS assessed earnings. So that may have something to do with this.
Thank you, Commissioner. Before we proceed further with Ms Harfield's evidence, I do need to raise something that's been raised with me by Counsel for the Commonwealth. And it's in relation to one of the emails that was shown to Ms Harfield in relation to summaries of Tier 1 AAT cases. I understand a concern's been raised that perhaps there should have been further redactions to that email because of the risk that what is presently unredacted in it may allow the identification of the relevant social security recipients concerned.
Okay, can you sort it out?
Yes.
With Ms Hogan-Doran?
Yes, Commissioner, and it actually has prompted us, working with counsel assisting and those instructing on both sides, to identify elsewhere in the statement and the accompanying materials and the exhibit list where there is identifying information as to Tier 1 social security recipients. Their identities are either expressly stated on the record or there's other information.
All right.
What I understand is proposed is that further redactions to deal with that issue will be prepared of all of those documents, and a form of order that's proposed to deal with it will be provided.
Thank you. Yes, Mr Scott.
Thank you, Commissioner. I should just forewarn that there will be some of those documents that I'll be referring the witness to, and I'll be asking that the witness see the document without it being brought up on the screen, so as to not cause that difficulty again. Could the witness please be shown Exhibit 1310, that is Exhibit 1310, doc ID CTH.3034.0032.7251_R.
Could you just tell me the exhibit number again, Mr. Scott?
1310.
Thank you.
You wouldn't happen to know what tab that is, you, or is it in
On our note, it's tab 49, I hope.
49?
Yes. Should be an email from Mr. Britton to Mr. Withnell CCing yourself dated 15th of January 2017.
No.
The witness might be directed to the second folder, which has the other emails, or other exhibits, I should say.
I'm so sorry, the exhibit number again, because that's tabbed up differently.
Sorry.
1310.
1310.
That's
Okay, yes, thank you.
So that should be an email from Mr. Britton to Mr. Withnell CCing yourself.
Yeah.
This can be brought up, can it? It's
Yes, it
not
can.
a problem.
I'll indicate the one that can't be brought up in due
Okay.
course. Okay, so, and you recall the exchange with the Commissioner earlier that in January 2017 there was an Ombudsman inquiry on foot. Recall that, Ms. Harfield? Have you had an opportunity to read this email in the course of preparing for your evidence?
So this was one that was provided this morning.
I see.
So,
Have you-
so I haven't read every line of it, because there was quite a number of documents, but I've got it in front of me.
Well, you can see it's a chain that ends with an email from Mr. Britton to Mr. Withnell seeing yourself on the 15th of January. And that forwards an email from Mr. Britton and Mr. Withnell and someone called Mr. Brown, dated the 21st of January 2015. Do you see that?
So I can see an email from Friday the 23rd of January 2015 from Scott Britton to Mark Withnell.
Is that the middle, from the middle of the first page of the document?
So the exhibit is tabbed 1310,
Yes.
and that is that email. That seems to be the only document.
Oh, I think you've got the attachment, Ms. Harfield. There might be a previous document.
Does that have a diff? Oh, there's
Oh,
another
could I just
tab.
interrupt to assist? I'm told there are two exhibits numbered 1310. One is dated 23 January 2015 and the other one is dated 15 January 2017.
Yes, I've got both.
And I
of
think the
those
witness has both.
Okay, tell me the second date again.
One is forwarded DSS comments, the one that I think is on the screen, which is dated 15 January 2017. And the other one that perhaps is mislabelled, but is some reading, 23 January 2015.
And do we think the exhibit number is actually wrong, or just that it's
They're
been-
both 1310 in my bundle and in the witness's bundle.
I'm just
And
wondering
I'm
whether-
told,
I understand, Commissioner, the numbering is
And in the
correct. They're supposed to be one together, one exhibit.
Oh, okay, they're both part of 1310. All right.
And the reason for that is the email from the 23rd of January 2015 is the attachment that's referred to at the top of the page.
Now you're confusing me. At the top of which page?
Of the 15 January 2017 email chain. There's a reference in that email from Mr. Britton to Mr. Withnell, has attachments, and then the word "some reading."
Oh, I see.
Yes.
Okay.
And you can see, Ms. Harfield, that the document called, or the document dated the 23rd of January 2015 is headed "Some Reading." Can you see that, Ms Harfield?
Yes, yeah.
Thank you. All right. So, I regather my thoughts. I can just come back to the chain that ends on the 15th of January 2017.
Yes.
Understand what I'm referring to?
Yeah, the email that starts Mark.
Yes. And if we go to the bottom of that chain, on the second page, there's an email from Kath Halbert, dated the 20th of January 2015.
Yeah,
And it's addressed to a number of people, including Mark Withnell. See that?
yeah, yes, yeah,
And Melissa Ryan, but Mark Withnell is
Yep.
also under SC. CC'd to a number of people, including Serena Wilson. See that?
yes,
And given the date and what's discussed in the email, would you accept that what's being referred to is DSS comments on a document called DHS Welfare Integrity Options?
yes, that's the subject, yeah.
Do you have an understanding of what that subject matter is or was?
I don't know in terms of options. What I understand is that the budget measures were related to, you know, strengthening the integrity of welfare payments, yeah.
That is, that what was being commented on was a document relating to that then proposed budget measure strengthening the welfare of...
Well, possibly. I mean, I can't definitely confirm that because this is more than a year before I
Yes.
joined the department. So I don't know if those two things are exactly the same thing or not, I think is just really what I'm saying.
The reason why I'm asking you these questions is that the email chain, as you would have seen, culminates in an email from Mr. Britton to Mr. Withnell CCing you.
Yep.
So what perhaps I'm suggesting is that you, in some shape or form, must have been informed of what the context of this email was.
I don't recall that, and I am CC'd into it. And as I say, I think in terms of that January period where we were sort of responding, I mean, there would be a lot of documentation that I was copied into that I wouldn't necessarily recall specifically.
Do you recall in that January period discussion within the department about inquiries by the Ombudsman in relation to a briefing to Minister Morrison in early 2015 in relation to the then proposed measure that became the Robodebt scheme?
No, my only sort of reference back to Mr. Morrison was a conversation, I think, with Melissa Golightly and Mark Withnell in relation to the sort of timing of the development of the measures.
Nothing about the briefing Minister Morrison received in early 2015 in relation to the development of those measures?
Not specifically about that sort of an event like that I recall, no.
Or about the Ombudsman's inquiries as to what Minister Morrison was told by the department in early 2015?
No.
And you can't assist us, is this right at all, with the context of this email chain?
No.
Okay. Can I just ask you about one topic in this email? If we go to the email on the first page from Mr. Britton to Mr. Withnell, dated the 21st of January 2015.
Yep.
And I call out the 3 bullet points in that email under the heading PAYG cleanup. Can you just read those bullet points to yourself without reading them aloud?
Yep.
Do those 3 bullet points accord with how the program was described to you by Mr. Withnell in his briefings to you in early 2016 when you started in the department?
So, I mean, in terms of those specific words, I wouldn't, I can't recall those sort of specific words, and the briefings were sort of really based on a set of sort of PowerPoint slides. But in terms of, I mean, the characterisation of PAYG cleanup, so this sort of concept that there were more reviews that could be achieved if the online process was sort of implemented as a basis for the budget measure does accord with that, yes.
Does it accord with the substance of what Mr. Withnell told you in early 2016?
Were you given to understand that the PAYG information gave the period the individual was employed and the amount paid, and that would be given to the recipient, that the recipient could provide detail as to the fortnightly breakdown of the income, and that if they didn't respond, the income would be smoothed, or didn't respond or chose not to give that breakdown, the income would be smoothed? Were they points that were made
Yeah,
to you?
I don't, I mean, the word smoothed I don't particularly remember, but yes.
Smoothed or averaged,
Averaged,
or
I think,
apportioned
yeah,
sometimes?
was the way it was more described to me.
Okay, thank you. That can be taken down.
It's hard to go past the further bullet point that says the proposal provides for an automated assessment of debt. This will reduce administrative error. That's just an observation, Mr. Scott. It's not a question.
Thank you. Now, Ms. Harfield, I'm going to ask you about some things in your statement and a document referred to in your statement, which I'm going to ask not be brought up on the screen because it reveals the details of someone subject of a Tier 1 AAT case.
Okay.
So I'm going to endeavour to take you to those passages without revealing those things. So if I can start with page 46 of your statement.
Okay.
And there's a paragraph there, paragraph 171.
Yes.
Refers to an email from Annette Mussolino to Secretary Leon, copy to you. See that?
Yes.
Dated the 26th of February 2018.
Yes.
And it's an email purporting to inform the Secretary of a matter that may raise issues in relation to the employment income confirmation process and may attract media attention. Do you see that?
Yes.
And it refers to a particular case in which the AAT Tier 1 decided that the debts were to be recalculated. See that?
Yes.
and it says that the decision contains comments that are critical of the department and of the OCI process, notwithstanding that the debt was not in fact an OCI debt. See that? It's in the last passage in that.
Yes, yeah.
Thank you. Now, do you recall this email?
I mean, not sort of specifically as an individual sort of case, but certainly in terms of being provided with information that then would have sort of required action on behalf of the customer by the debt area, yes.
What do you mean by, in terms of being provided with information that would then sort of require action on behalf of the customer?
So in terms of the sort of judgment, obviously that there's a requirement for us to sort of do some recovery action with the customer around the outcome from the AAT decision.
Right, so you recall, in a general sense, having the department having to take action following decisions, Tier 1 AAT decisions
Yes,
like this.
outcomes in the AAT. Yes.
Right. What role were you in at this time of this email?
So at this point, I was in a newly formed division, which was called Information, Debt and Appeals. So that sort of previously been two divisions, and so I returned to customer compliance at sort of the end of March, and I was moved into this new role in May of 2017.
Okay. And did that role involve you in the departmental responses to decisions such as this?
In terms of if recovery action was required for the customer, yes.
Okay. And if we go down the page, again, not wanting to call out this part of your statement, you refer in paragraph 173 to an email sent by Ms. Mussolino to Ms. Leon, copied to you. Do you see that?
I do.
And you can see that it's in relation to the same matter that's dealt with in paragraph 171.
Yes.
And in paragraph 2, you can see an explanation of the comment that it was not, in fact, an OCI debt in the case. Do you see that?
That it was a manual process, yeah?
Yes.
Yes.
And by manual process, given the timing, October 2015, that would be a process undertaken under the manual intervention?
Yes.
Okay. So, even though the process was manual in the sense that it was completed by a compliance officer, it would have still used income averaging to calculate the debt. Do you accept that?
Yeah, I mean, the email says that averaging was used in that case, yes.
Yes, and in the way that we've discussed, that is, because the recipient involved did not provide information in response to the contact from the department, averaging was used to then calculate what their income was.
Yes.
And if you go up the page in your statement, the words are, the member decided that because the department had calculated the debt on the basis of averages derived from the ATO and had not used its compulsory powers to obtain actual fortnightly earnings figures from employers, there was insufficient evidence to establish an overpayment or its size. Do you see that?
Yep.
And then the balance of the document, the email that is from Ms. Mussolino, purports to answer the question, is the following practice of averaging defensible and reasonable? Do you agree with me on that?
Yep.
And these words appear, following the heightened interest in the OCI process in 2017, questions were raised by various commentators about the appropriateness of the department's decision-making with respect to overpayment debts. Of particular focus was the department's practice of averaging. Averaging is the process by which the department assumes that an income amount earned in a particular financial year or part year was earned on a fortnightly basis for the relevant financial year or part year. Averaging has historically been used as the basis of a decision to raise a debt in the absence of other contrary information such as bank statements or payslips. Do you see that?
Yes.
Right. Now, what's of course missing from that statement in referring to what historically had been done is the fact that historically the department would make inquiries to find out if such contrary information existed. Isn't that right?
So my understanding was that in the prior to July 2015, that was correct. In the period from July 2015 to July 2016, there was an interim process which involved not seeking the information from the employer, but getting the information from the customer. And then in the post sort of July 16, that was facilitated using the online compliance system rather than a compliance officer.
This is talking about a debt raised by a decision in October 2015. You've agreed with me on that?
So that would have been that sort of interim process.
Yes, but this passage here is talking about what historically had occurred. Those are the words. Averaging has historically been used as the basis of a decision to raise a debt. Do you see that?
Yes, yep.
So, of course, you'd agree with me, wouldn't you, that that's purporting to refer back to the pre-July 2015 practices?
I don't know if I can confirm that because there isn't a date in there and there were at least two sort of versions of that process.
But given the context of this document, you'd agree, wouldn't you, that the fact that averaging had historically been used was being relied upon as a basis to justify the practice of averaging?
I mean, that's how it reads. I'm just saying in relation to this particular instance, I can't say exactly what the historic time is.
Well, you're prepared to agree with me that it's not talking about what was historically happening in respect of this particular case. It's talking about in a general sense, what historically was happening.
Yes, but in the history, there were two different versions, I think is all I'm just trying to be clear about.
Right. Are you saying that the words averaging has historically been used as the basis of a decision to raise a debt? Are you saying that that could be used to refer to a period after July 2015?
No, I'm sorry. I don't think I understand what you're asking me there.
Are you suggesting that that phrase, averaging has historically been used as the basis of a decision to raise a debt in the absence of other contrary information? Are you purporting to suggest that that statement could be read as referring to a period after the July 2015?
I'm sorry, I still don't really understand what you're... I understand you've repeated the question, I just don't really understand what you're asking me in relation to it.
Well, I'm asking you, is there any other interpretation of those words than this, that it's referring to what was historically the practice prior to July 2015?
So my understanding is that the historically element would be any time prior to this case.
Right, which would include the period prior to July 2015?
Yes.
Okay. And you'd agree with me that what's missing from the description of what was happening prior to July 2015 was that averaging was only occurring as a last resort after all other inquiries were exhausted.
It doesn't say that in that email, no.
Yes. And you'd agree with me, therefore, that in that respect, that aspect of the email is misleading.
It doesn't contain the content. I don't know that I would categorise it as misleading. It doesn't contain that content, no.
Well, it's seeking to suggest, I would put to you, that averaging has historically been used, including prior to July 2015, as the basis of a decision to raise a debt in the absence of other contrary information such as bank statements or pay slips, regardless of whether that's occurring as a last resort.
So you're, sorry, I am trying to follow what you're asking me. I just don't understand what you're asking me.
What I'm asking you is, this passage is seeking to suggest that, including the period prior to July 2015, averaging was not being used as a last resort.
Oh, right, okay. Yeah, I don't know that I particularly have read it that way, but it doesn't use the phrase last resort, no.
And that it's seeking to suggest that prior to July 2015, averaging was a routine practice.
I don't know that it says that either, but it does talk about averaging. It doesn't use the words routine practice, no.
Well, if it was intended to, if it was to be read in any other way, then surely it would put the qualification that prior to that time, that is July 2015, it was only being used as a last resort, that is after all possible inquiries had been exhausted.
Possibly. I mean, I didn't draft the email, but...
Well, I'm asking you, as a person who was copied to this email, whether, having received it, it would appear to you that it's not a fully complete and accurate statement of the position prior to July 2015.
Yeah, I don't really know. I mean, I think that I was copied into the email. I don't recall whether I read it at the time or not, specifically. And it is a description in response to a request from the Secretary. I don't know that I can tell you any more about it, really.
All right. Well, I'll ask you about one last document, and again, I'll do it by reference to your statement without it being brought up on the screen. Paragraph 177 on page 47. Sorry, paragraph 175 on page 47. You refer to an email being sent to you attaching an executive communication that had been noted by Secretary Leon. Do you see that?
Yes.
And refers to an email and attachment relating to a briefing paper. Do you see that?
Yes.
And then the next paragraph refers to the executive communication that's described in the preceding paragraph.
Yes.
Okay, if we go over the page, top of that page is what's stated to be the subject purpose of the document. See that?
Yes.
And it says, the purpose is to advise you of a meeting to be held on 16 May 2018 between the Commonwealth Ombudsman and officers of the Department about legal issues relating to debt recovery. Do you see that?
I do.
Okay. And then the body of the communication is quoted under paragraph 177 of your statement.
Yep.
And it says, refers to the Commonwealth Ombudsman, Mr Manthorpe, requesting a meeting about legal issues relating to OCI. Do you see that?
Yes.
And that the request was made following the publication of an article in the University of New South Wales Law Journal Forum. Do you see that?
Yes.
An article by Professor Terry Carney. Do you see that?
Yes.
Okay.
Yep.
Do you know who Terry Carney is?
I don't know him personally. I mean, I do recall reading the article as part of a part of media sort of reporting. Yes.
Yes. But do you know that he was, apart from being a professor of the university, a member of the Administrative Appeals Tribunal?
Previously, yes.
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 And who'd been making certain decisions about, making certain decisions in relation to debts that have been raised by the department against social security recipients?
Well, I do know that now. I'm not quite sure whether I knew that at the time, but yes.
Okay, so you don't recall knowing that he was one of the AAT members that was setting aside debt decisions because of the use of income averaging?
Not specifically, no.
But you read the article?
Well, I don't know if I read the whole article, but it was certainly in sort of media reporting in the department, yes.
And you knew enough about the article to know that one of the central issues that he took in the article was that he said that income averaging in the way that was being used by the department under Robodebt was unlawful.
That was, yeah, what he was putting forward, yes.
Right. And this document was seeking to address that issue.
Which document?
So the executive communication document that you're referring to in your statement.
Well, it was identified as, you know, an issue that the secretary at the time that the Ombudsman wanted to raise with the secretary. And,
Yes.
and I was copied into that correspondence, yes.
And do you have awareness of why the Ombudsman wanted to raise the issue with the secretary?
I think by this point, in terms of online compliance, which was, I think, now under a different iteration and had a sort of different description, if I'm correct, was mostly dealt with within the newly formed integrity modernisation sort of area. So I'm copied into it for awareness. In relation to individuals and AAT matters where we needed to you know, actually initiate some sort of action with a customer as a result of an outcome, then yes, but not sort of more broadly than that.
So my question was, do you have awareness of why the Ombudsman wanted to raise the issue with the secretary?
No.
Okay. Now, on the quote towards the bottom of that page, do you see that the words appear, which is the quote from the executive communication, the department disagrees with Professor Carney's analysis and believes he has fundamentally misunderstood aspects of the OCI process. See that? Under the bullet points.
Oh, under the bullet points. Yes, I do.
Thank you. And then would you agree that there's, in the following paragraphs over the page, a purported description of the process that was being undertaken in the Robodebt scheme?
In terms of the paragraph that sort of commences with 3 dots.
No, I'm talking about after that paragraph ends with, and believes he has fundamentally misunderstood aspects of the OCI process, the 3 paragraphs that follow.
Under that, yes, okay, I can see those, yep.
Do you agree that that purports to give it a description in general terms of the OCI process, or what was then perhaps the EIM process? Sorry, EIC process.
Yeah, I don't know specifically, what sort of phase that's relating to, but it is a description of the process, yes.
What might be said to be the fundamentals of the Robodebt scheme. Okay. Then the next paragraph on the next page, commencing with the 3 bullet points, which is taken, again, quote from the executive communication document. These words appear: where customers fail or refuse to provide information which would clarify any discrepancies identified, the department is entitled to make a decision on the best evidence available to it at the time. Do you see that?
I do.
Now, you agree that that is, on its face, would be seeking to suggest that is what was occurring under the Robodebt scheme. That is, the department was purporting to make decisions based on the best evidence available to it at the time.
Yes.
And that was simply false, wasn't it?
Well, not necessarily exclusively false, but on occasion it would not have been correct.
Well, systematically under the Robodebt scheme, debts were being raised after recipients weren't responding to initial contact in the initial letters, without any investigations then being undertaken by compliance officers as to whether there might be other evidence available to calculate the debt.
Yeah, I'm just saying that wasn't for it, like every case.
No, not every case there would be a lack of response from the recipient. I'm just talking about the cases where recipients didn't respond.
Yes.
This statement is clearly false, isn't it?
In relation to customers who didn't respond.
Yes. Thank you. Now, as we've established, Ms. Harfield, this document was attached to an email sent to you on the 11th of May 2018. If you recall what was said in paragraphs 175 and the start of 176 of your statement.
Yep.
And it was, as appears from the quote of the email on the 11th of May 2018, it was provided to you as for your information exercise. Do you understand? Do you agree with me on that?
Yep.
And so it was intended that you read the attachment. You accept that?
Well, it certainly would have been provided to me so I could read it. There's not a specific instruction to read it or action it, I suppose. No.
Well, are you going to suggest that you didn't read it?
No, I'm not.
Okay, so you accept you did read it?
I don't specifically recall reading it, no, but...
Given that the communication that's attached, that's addressed to the Secretary, contained a statement that at least in a significant part was clearly false, can you explain, can you tell us whether or not you did anything to bring it to the attention of the Secretary that it did contain that falsity?
No, I don't, at the time, I don't recall having that view of the paragraph.
Well, that view that you're referring to, that part of that paragraph, at least in part, was clearly false, would have been obvious to you, wouldn't it, if you'd read the document?
Well, I don't know. I didn't form that view at the time, so I can't really say anything else apart from that.
Can you explain how you didn't form that view at the time?
Well, I mean, I don't know when I opened the email, I don't know when I read the email, because it was sent to me on a particular day. It doesn't mean I necessarily engaged with that. It was, copied to me. There's a lot of email, a lot of work traffic. I just, your sort of concept, I suppose, of this was the one thing that I was sort of dealing with, that's just not how it was working. So I don't have that sort of recall specifically about what I did in relation to this.
Well, is it the case that you didn't do anything about that?
I don't believe I did do anything, no.
And is it the case you didn't do anything about that because you're indifferent about the falsity in that paragraph that we've been discussing?
No.
Okay. Just one last topic, Ms. Harfield, and this can be brought up on the screen. It relates to paragraph 205 of your statement on pages 54 and 55. And you state that upon returning from leave in March 2017, Ms. Golightly informed you that you were being moved to the newly formed Information Debt and Appeals Division. And as part of that discussion, Ms. Golightly said she had spoken with the Secretary who approved your move to the new role. You say that Ms. Golightly said that she had to do something with you because it was her opinion that you could not get on with Mr. Withnell. Is it the case that you could not get on with Mr. Withnell?
I don't think so. I think what I was trying to raise with Melissa was a sort of concept around revisiting the measure in general, and it didn't really matter from my perspective how I attempted to engage her with that. She didn't seek, or I suppose value, was my sense, any of the sort of reflections about the measure and about how you might respond to it. And really, as a result of Jason McNamara coming in to sort of provide this strategic oversight of the measures going forward, in combination really with Mark Withnell still in the sort of BI role, there was more a sense that she saw Mark as the person to provide her with, I suppose, strategic input, and she very much felt that when I raised issues with her, that was about a challenge to her, and that it was unacceptable to have any sort of contestability around the budget measures, that my focus should be on the numbers and the volumes of reviews, and she was content and confident, as I said previously about the measures, in relation to what had been designed and implemented.
Am I correct in understanding that what you've just described is your belief as to the reasons why you were moved?
Yes.
Does that reflect anything Ms. Golightly said to you, or is it your interpretation of what Ms. Golightly said?
So well, it's not just my interpretation, it was the behaviours and the actions through that whole time.
Right.
And beyond.
And by behaviours and actions through that time, are you referring to how Ms. Golightly responded, for example, in January 2017 when you raised concerns about the scheme?
Well, and not just the January. I mean, it was through the whole so once the volumes had started to increase and we had systems issues, we had recovery action, we, as a division, were responding to the customer dissatisfaction, there was the AAT reporting. So as a whole, what that said to me was that the system was not working as it had been conceived, And that was why I made the suggestion about having a major incident response. And really from that point, or throughout that whole sort of period, I was unable to influence Melissa in terms of any sort of shift from the focus or the direction of deliver the numbers.
Right. And just in terms of your relationship with Mr. Withnell, was her comment that you couldn't get on with her, did that reflect your experience?
I don't know that it was particularly not get on. He came across to me as, slightly surprised that a new division had been created. He certainly saw the measures as, something that he had developed and delivered to a certain point. And so felt that he was very much still sort of in control of it, and that my job, again, was really about the sort of practical implementation element.
Commissioner, that's the evidence of the witness.
I just want to ask you about 2016. There had been pilots in place between about July and September involving a couple of thousand cases.
Yes.
And then in September, we ramp up to 60,000+ cases.
Yeah.
Whose decision was that?
That was at Melissa's request.
Do you remember Mr. Ryman expressing some concern to you about that?
Well, I think, certainly in terms of the system being sort of, I suppose, behind what Melissa sort of considered the place it should be in terms of the numbers, I think there was a general concern about how we were going to achieve an increase in the numbers, and a requirement to make sure that the system was doing what it had anticipated to be done. So I don't know that there was a specific concern from Mr. Ryman. I'm not saying there wasn't, but I think it was something that, we were collectively concerned with how are we going to achieve the increased numbers.
See, you were still getting glitches in the small pilots, weren't you?
I think that we certainly had some system issues between that July period and the September, and those were, that was part of the briefing that I would give to Melissa. I think I was away and Scott acted for me for sort of 1 week, and there was a briefing document that Melissa had asked me for as a sort of response to some of these concerns, and that had been prepared. And when I returned from leave on the Sunday, there were a number of emails waiting for me from Scott before I started back into the office on the Monday, where he said that Melissa had decided she no longer wanted the physical brief, but that he had briefed her on the issues. So yes, there were issues raised as the process continued.
Well, what Mr. Ryman said about it was that he had said to you that he didn't think you were ready to do this, in other words, take the numbers up, because you were really still getting through the pilot phase, and that you should be making sure that they could be done properly before launching the large numbers.
Yeah, I mean, my sort of sense of Mark, Scott, and Jason were actually the people that were sort of most confident in the measure. I was probably the person that had least sort of experience of the type of activity that they were sort of undertaking. So I don't particularly recall that.
Okay, I'm just putting these things to you because I want your response to what
Sure.
he said. He said he was told that this was proceeding in a meeting that involved you and I think it's Gary Clark, is it?
Yes, he would have been.
And that between you, you told him that it was going ahead and asked whether he had anything to add.
So Melissa was very clear about the requirement to increase the numbers by the end of September, yes.
So is that how you conveyed it to Mr. Ryman? Do you remember?
Yes, I would have done.
Okay. And then Mr. Britton, I think, says he was on leave when that increase in numbers happened
He might have been.
and didn't find out till he got back.
He might have been on leave, yeah.
All right, thank you. Anything arising out of that, Mr. Scott?
And there's nothing arising, Commissioner.
Okay, thanks, Ms. Hogan-Doran. Mr. Scott?
Might the witness be excused?
Yes. Thank you, Ms. Harfield. You're excused.
Commissioner, I call in Lumley.
Thank you. Jess, can you take this? Mr. Lumley, will you take an oath or an affirmation?
Affirmation.
All right, thanks. Would you stand up and
The reply is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Lumley, would you please tell the Commission your full name?
Yeah, it's Benjamin Anthony Lumley.
And you were provided a notice from the Commission to give a statement and produce documents dated the 25th of October 2022.
Yes.
And you produced a statement in response to that notice dated the 4th of November 2022.
Yep.
You were given a further notice dated the 17th of November 2022.
Yes.
And you produced a statement in response to that notice dated the 30th of November 2022.
Correct.
Okay. The facts stated in your statements true and correct to the best of your knowledge and belief?
They are. There was a late correction as of this morning to the second notice. I'm not sure if that's been communicated.
Second statement?
Yeah, the notice to give 0085.
Yes, so that's the statement provided in response to that notice. Statement is dated the 30th of November 2022.
Yeah, that one.
Is that right? Do you have a particular paragraph reference you want to identify?
Yes, so bear with me. I think it's 19J. Just let me be sure about that. Yes, 19J. That statement, that line there is incorrect. It actually should be the same as 21G.
Right. So the words that appear in 19J on page 16
Yep.
should be replaced with the words that appear in 21G on the same page.
Correct.
Okay, thank you. And the statements are otherwise true and correct to the best of your knowledge and belief?
Yes.
Thank you. You're not presently employed by government.
Correct.
You're employed by a private company at present.
Yep.
But prior to that, specifically between the September 2014 and July 2018, you were Director, Data Strategy and Analytics at the Department of Human Services.
Right.
Okay. That team, that is Data Strategy and Analytics, you also refer to with another name at paragraph 12, I think, on your statement on page 3, which is Case Selection Team.
Correct. Yeah, the same team had a name change. That was its former name.
And you say in that paragraph that you had responsibility in that capacity for approximately 20 different data exchanges with external government organisations, including the ATO. Agree with that?
Yep.
And you define a data exchange as provision of data from one agency to another.
Yep.
Okay. Is this this concept of data exchange also encompass the concept of data matching?
Generally, it does, yes. If data matching, sometimes you use the term to align records, so you've got the same individual on both sets of data that can be used for that. But yes, some people use the term data matching to represent an exchange as well.
Okay. And one context in which data matching might occur would be matching two sets of personal information held by two agencies
That's right.
for the purpose of a purpose carried out by one of those agencies.
Yep.
Okay, and one of those purposes relevant to this matter was the process of data matching Centrelink records against ATO PAYG data for the purpose of investigating discrepancies in declarations of income by recipients
Yes.
of Social Security. Okay. In the capacity that we've described, that is Director of the Data Strategy and Analytics team, given the role involved data matching, would you be familiar with the guidelines on data matching in Australian government administration published by the Office of the Australian Information Commissioner?
Yes, I'm familiar.
The answer is yes?
Yes.
Thank you. Can we have on screen Exhibit 505, Doc ID ATO .9999.0001.0003? Do you recognise that document, Mr. Lumley?
I have seen it in other formats, but I assume that's like an extract from a web page of the guidelines. It looks like I've seen it sort of printed as a PDF differently to that, but
I see. But have you seen it printed in this format?
not. Sorry, it's other than today when it was provided to me. No, but it's in that format in the documents provided to me today.
So have you been provided this document in this format to you today?
Yes.
Do you have a hard copy with you?
I have that in front of me now.
You have it?
Yep.
Okay. Do you agree with me that that purports to be the guidelines on data matching in Australian Government Administration dated the 18th of June 2014?
Yes.
Would you agree with me that they were the relevant guidelines in force at the time that the Robodebt scheme was initiated, firstly at the time of the manual intervention in 2015 and then subsequently at the time of the online compliance intervention in September 2016?
Yeah, based on the 18th June 2014 date. Yep.
That was in force at those times. Okay, thank you. All right. Now, I'm just going to ask you about some parts of this document. Firstly, just to provide the context of some questions that are going to follow. So I'm just going to draw your attention to them and ask whether you agree with me as to what those passages say. So first of all, we've got the key terms section at the top of the document. And being familiar with this document, you'd agree with me that this is a section of the document that purports to define terms used in it. Do you agree with that?
Yes.
So for example, this term under the heading key terms, administrative action, that's a term that's subsequently used in these guidelines. You'd be familiar with that, wouldn't you?
Yes.
Thank you. And you'd be familiar with the definition that appears there, which is, and it gives examples of, to illustrate the definition, but the main part of it is that administrative action is action taken in response to a match obtained through a data matching program that materially affects, partly obscured, but I suggest the next words are any individual or class of individuals. Do you see that?
Yes.
You agree with me? Yep. Okay. And then we go down to the middle of the page and we've got definitions of terms related to data matching.
Yes.
In particular, firstly, we've got the definition of the term data matching itself. That is the bringing together of at least two data sets that contain personal information and that come from different sources, and the comparison of those data sets with the intention of producing a match. Do you agree with me on that? Yep. Okay. And then the next relevant definition is data matching program. I'll skip over the data matching cycle. That is, so for data matching program means the conduct of data matching to assist one or more agencies to achieve a specific objective. And a data matching program may involve more than one data matching cycle. Do you see that?
Yes.
Okay. And if we go over the page, firstly, the section headed, who should use these guidelines? In particular, paragraph 2 says, this document should be used by agencies that handle personal information and wish to use data matching to determine whether administrative action is warranted. Do you see that?
Yes.
Okay. And then paragraph 6, same page, the words, these guidelines, which are issued under a section of the Privacy Act, are voluntary, but represent the OAIC's view on best practice with respect to undertaking data matching activities. Do you see that?
Yes.
Okay. And then if we go over to the page with the last digits 0003, I think. Yes. You can see towards the bottom of the page, section guideline 3, prepare a program protocol. See that?
Yep.
And the concept of a program protocol would be of significance to you, I suggest, given your knowledge of these guidelines and your role at DHS at the time that we've been discussing.
Yes.
Right. And in particular that, in fact, you'd be familiar that what these guidelines require, amongst other things, is for agencies involved in data matching programs to prepare protocols in relation to those programs. You agree with
Yes,
that?
that's the guidelines do outline that. Yep.
Okay. And we look at guideline 3 summary section, in particular the words under the section 3.1 subsection C. Would you agree with me that the effect of this section is that before commencing a data matching program, the primary user agency should make the program protocol publicly available? You see that?
Yes.
Okay. And that is, related to that is what is in section 3.3, which says that the purpose of the program protocol is to inform the public about the existence and nature of the data matching program. You see that? And given your previous role, you would be familiar that the statutory context in which these guidelines were made was the regulation of government agencies' use of personal information by what's known as the Privacy Act. Are you familiar with that?
Yeah, I think it mentions it's to help with best practice against the Privacy Act.
Yes, but-
agency best practice.
Yes, but the broader context is this is under the framework of the Commonwealth Privacy Act. You'd be familiar with that?
Yep.
Okay. And the general object of the Commonwealth Privacy Act is to regulate how government agencies deal with personal information of Australia's citizens. You agree with that?
I don't know it, it's a complete scope, but that I would imagine that would govern that or cover that, yes.
Okay. Would you have an understanding that if one of the objects of 3.3 of this guideline is to ensure that the protocols in place for the use of personal information in data matching programs are publicly available so that those protocols are transparent?
Mm.
You agree with me on that?
Yes.
Okay, thank you. All right. Now, at the bottom of that page under the section heading, what should the program protocol contain? And you'd agree with me that this part of the guideline purports to prescribe what should be, as a minimum, in a data matching program protocol?
Yep.
Okay. And I'm interested in particular in what appears on the next page. We've got effectively subparagraphs of section 3.4, Roman numeral 5. What's required includes a brief description of the matching process, the output produced, and the destination of the results of the program. You agree with me on that?
Yes. Yep.
And then Roman numeral 6, what action, administrative or otherwise, may be taken as a result of the program.
Yes.
You agree with me on that? And you'd understand that that's a reference, when it talks about administrative action, it's a reference to administrative action as defined in the key terms. Thank you.
Before, yes.
And then Roman numeral 7, time limits applying to the conduct of the program. Agree with me on that? Okay. And then in subparagraph B, protocol is required to set out an explanation of the reasons for deciding to conduct the program, including the legal authority for the uses and disclosure. This is in Roman numeral 2, the legal authority for the uses and disclosure of personal information involved in the program. Do you agree with me on that?
Yes.
Okay. Further down the page, section 3.7 says that the OIC recommends that the primary user agency publish the program protocol for the data matching program on its website. Do you see that?
Yes.
Okay. And then further down the page, section 3.10 and 3.11 under the heading changes to data matching programs. 3.10 says, when a primary user agency wishes to change or amend an existing data matching program, the primary user agency should revise the program protocol to clearly indicate the amendments. See that?
Yes.
Now, at the time of your duties in the capacity we've been discussing at the DHS, were you aware of this requirement?
I became aware of it.
When did you become aware of it?
It was, I can't call exactly when, but it was when reviewing the program protocol for the pay-as-you-go matching in response to, I guess, media inquiries or media attention to the Robodebt scheme.
Right. So after the OCI scheme went live, that is at full scale in September 2016.
Yes.
So this is by a time that the manual intervention has already happened.
I can't be sure about that. Do you mean the manual process prior to?
Sorry, my question was terribly phrased. You're saying, your evidence, I take it, is that you weren't aware of this requirement in 3.10 of the guideline at the time that the manual intervention occurred in 2015 and 2016.
Correct. That's what I'm saying, yes.
All right. And indeed, weren't aware of it as the OCI program started to be implemented in 2016 and then became fully live in September 2016. You weren't aware of it then?
That's right.
Okay. And so would we be right in saying that you weren't aware of what's said in the requirement in 3.11 that the primary user agency should notify the OAIC of the amendments and provide the OAIC with a copy of the revised program protocol? That is, you weren't aware of at the times that we've just discussed?
Yes, that's right.
Thank you. Now, we go then to page with the last four digits 0007, which was the top of that page, is headed Guideline 7. Now, this section headed Guideline 7, destroy information that is no longer required. Are you now familiar with the contents of this section of the guideline?
Yes, I am now.
Okay. Were you aware of it at the time of the manual intervention?
Yeah, I was aware that the guidelines did require or did recommend destruction of data and timeframes around that. Yes.
Were you aware of the actual specifics of this part of the guideline?
I recall, I'm not sure if it actually makes reference in this section, like guideline 90 days, I can see it there. I was familiar with like that recommendation, that sort of raw data that you use for data matching processes, if there's a decision to no longer need it or use it, that 90 days is a guideline for its destruction.
Had you read this part of the guideline, that is the entirety of these words under the heading Guideline 7, destroy information that is no longer required?
So had I read it?
Yeah.
I may have. Like, do you mean back?
Yes.
That period of time? I may have.
Back at the time of the manual intervention, you may have read it?
Yeah, I mean, I had access to it, but I can't recall if I'd read.
And likewise, you can't recall whether you read it at the time of the online compliance intervention?
No, I can't recall.
That is, when I say at the time, I mean at the time it went fully live in September 2016.
Yeah, I can't recall. The recollection I have is I was very familiar with that 90-day kind of guide, because it was sort of implemented in some of our technical processes where it would go through and clean up data based on that recommendation.
Right. So we just highlight section 7.4 first of all. That is all of it until just before 7.5. Perhaps, yep. Now, you'd agree with me that this deals with a situation when personal information is no longer required, and it requires that that information should be destroyed as soon as practicable after the completion of the data matching cycle, and at least within 90 days of the completion of the data matching cycle. Okay?
Yeah, the 90 days is kind of the at least, as it said. So it's as soon as that decision is made or the data is no longer required, as soon as possible.
Yes, but at least within 90 days. Okay. And then section 7.5 is a similar requirement, it's slightly different circumstance. That is, a decision as to further action in relation to each individual should be taken by an agency within 90 days of the data matching cycle. You see that?
Yes.
Were you aware of that requirement during the manual intervention?
I can't recall if I was aware at the time of that one. Yeah, the 90-day sort of, my recollection of 90 days is points above. I don't recall my knowledge of this one at that time.
What about when OCR went live in September 2016?
Yeah, I'm sorry, I can't recall my knowledge at that point.
Right. Would you agree with me that the effect of it is that when a match occurs in the data matching cycle, a decision as to further action in relation to each individual should be taken by an agency within 90 days of the data matching cycle? You agree with me about that?
Yeah, that's, you can interpret it like that way, yes. Saying it should make a decision,
Yes.
take action, isn't it?
and shouldn't just, sorry, I didn't mean to cut you off.
Oh yeah, I agree. Yeah.
And further, that it's not open to an agency to just sit on the data for more than 90 days without making a decision about what to do with it.
Well, following this recommendation, then no. So, you know, if they abide by that recommendation,
You're
they should
agreeing
make
with
a
what I
decision-
said?
Should make a decision within 90 days.
Yeah, okay. That document can be taken down. Could the witness please be shown Exhibit 1109, that is 1109, Doc ID CTH 3000.0028.6814. See that document, Mr. Lumley? You recognise that document?
Yes, I do.
That is the program protocol for pay-as-you-go data matching in force at the time of the manual intervention, correct?
Yes.
And at the time that the...
So just to clarify, when you say manual intervention, do you mean under the measures before like the online system?
Yes.
So yeah, yes. I mean, either way, but just want to be sure. Yes.
So after the budget measures were announced and
There was a period of manual intervention.
Yeah.
That's the one you're referring to. Yeah.
that went up to 2015 and then was taken over by the online intervention.
That's right.
Yeah, okay. So this was in force at the time of the manual intervention?
Yes.
Okay, and it was in force at the time that the online intervention went fully live in September 2016, is that right?
I think so. It was revised at some point. I think it still was. It wasn't revised at that point yet. So I agree. It was in force, in play, in force.
All right. And you agree with me that this document was not on the department's website at those times that we've just discussed?
Yep, correct.
The only way in which it had been made publicly known was that it had been published in the Government Gazette?
Yes.
All right. Go to page 10 of the document, please. You should have the last four digits. Oh, yes, that's it. And you can see there the section headed the matching process.
Yep.
And you agree with me, that's a purported compliance with the section of the guideline that we just discussed earlier that requires a protocol to set out the matching process under the program.
Yes.
Okay. And then on the next page, section 6, headed action resulting from the program. See that?
Yes.
Okay. You're familiar with this, the words in this part of the protocol?
To a point, yeah. I mean, yes. I've skimmed it in my pack that I've seen, and I did review it when I was producing my statements.
You would have been familiar with it at the time that the manual intervention was occurring, correct?
I was familiar with there was a program protocol, but I don't know about like my level of knowledge of this section and its content.
Or did you, in the course of your duties related to the data matching that was undertaken for the purpose of the manual intervention, did you have regard to this section of this protocol?
Sorry, do you mean to have regard to?
Did you have regard to it for the purpose of your duties in relation to data matching that was taking place under the manual intervention?
So I'm not sure what you mean by do I have regard? Do I have knowledge? Did I?
Well, in the course of your duties, did you review it?
No, not during the manual process. No.
Not during the manual process. Had you read it at all? Read this protocol at all at the time of the manual process?
I can't recall if I had at the time.
What about when the OCI scheme went fully live in September 2016?
As I mentioned earlier, I know I did review it. It was probably after that, I suspect.
After September 2016?
Yes.
Okay.
Yes.
When do you think you reviewed it?
may have been towards the end of 2016 or early 2017. I'd have to confirm that.
Okay. Well, assuming it to be at that time, that is at the end of 2016 or early 2017, do you agree with me that you would have reviewed this page at that time?
Yes.
And can we take from your evidence that at that time you reviewed it carefully?
I believe this section, I had someone responsible for the process, because I believe this covers kind of the, what was the term, administrative action. It kind of is aimed at covering that I had someone that had knowledge of that business process review this and update it.
Right. Did you review it yourself?
I can't recall if I reviewed it myself. I think I would have had a look at it saying it's not sort of, I don't have the area of expertise to redraft that, and requested someone else do that.
Okay. When you say you requested someone else to redraft it, when did you make that request?
It would have, as I said, either the end of 2016, early 2017.
Right. And did you make that request because it had come to your attention that this part of the protocol did not accurately reflect
Yes.
the administrative action that was going to be taken as a result of the data matching program then being undertaken for the OCI?
Yes, that's right.
Okay, thank you. And to be specific, we go to the first paragraph under the bullet points, call that out. You see the words, before commencing the review, Centrelink staff will check the customer's record to determine if the discrepancy can be explained. Do you see that?
Yes.
All right. Did it come to your attention in late 2016 that that statement, that is, Centrelink staff will check the customer's record to determine if the discrepancy can be explained, did it come to your attention that was an inaccurate statement?
Yes, I suspect that would have been one of the reasons or the things that stood out to me while I requested it to be updated.
Yes.
It no longer would reflect the process.
When you say it stood out to you, would you agree with me that you knew at that time that is not how the OCI worked?
Yes, at that time it was getting reviewed, yes. As I said, this part in particular, I did ask someone with sort of more intimate knowledge of the business process to update it, but I would have been familiar with that being inaccurate.
You had enough knowledge by that stage to know that that part of the document was false.
Yeah, at that point, yes.
And had you read this document in 2015, you would have known it was false, wouldn't you?
Not necessarily. My complete understanding of the business process downstream from the data matching was kind of, I didn't fully appreciate the process until later on, like around the end of 2016-17, of what actually was happening. So I can't necessarily say that, yes, I would have been aware of it in 2015.
All right. Well, just for the purpose of this question, I'm going to group the online compliance intervention and the manual intervention in the one category, which I'm going to call the Robodebt scheme. When did you first become aware that it wasn't part of the Robodebt scheme that Centrelink staff will check the customer's record to determine if the discrepancy can be explained?
So it's difficult for me to provide an exact time frame when I was aware of that. The measures sort of aim to engage customers online, to have them provide the information. I guess the automatic application of that didn't, I'm sorry, I can't be very specific around time frame, but it was, I know that it was during the process that I kind of realised at some point after the fact that that was where it was going, as in that's the scheme. There was opportunities where people would have income automatically sort of calculated and applied and done without the involvement of Centrelink staff member, as that says.
So can you give us a year when you became aware of that?
Oh, it would, possibly 2016.
Or part of 2016?
Towards the end. I can't be too sure. But.
All right. Now, next paragraph, pull that out, please. You see the words there, customer is given a period of at least 14 days from the date of the letter is issued in which to contact Centrelink in relation to the employment information. Do you see that?
Mm-hmm. Yep.
Okay. And you understand that to be a reference to the customer being given at least 14 days to contact Centrelink by any means that they choose, including by phone?
I assume so. Yes, it doesn't specify. So,
Well,
like the contact method. I mean, it doesn't specify. So,
it leaves open that.
yeah, they could contact by phone. Yeah.
Yes. And did you understand? Sorry, I'll start that question again. Do you now understand that the design of the Robodebt scheme specifically had the initial letters to the customer not have contact phone numbers in order to discourage customers from contacting Centrelink by phone?
So you'd say, am I now aware?
Yes.
That yes. I believe during the manual process there was a number, I think, and so some of the early sort of pilot activity, but towards the end with OCI, I believe the number was removed.
When did you first become aware that a phone number was not being given?
It would have been, again, I'm sorry I can't give an exact time frame, but would have been towards the end of the manual process, so the first year or so of manual process, the department was sort of gearing up to go online. It was at some point there, I do remember discussions around removal of the number and the reasons why, and the experience of other programs in the department, how that's worked, and I guess the reason for the decision to do that.
What was the reason?
It was to encourage customers to use the OCI, the online, rather than call.
Okay. We go to the next paragraph and call that out. And in particular, if we look at the last sentence in that paragraph, it says if the customer is unable to provide sufficient evidence, the employer may be contacted to provide further information. Do you see that?
Yes.
Okay. And you know now, of course,
Yes.
that did not occur under Robodebt.
No. Yes, I am aware. That did not.
When did you first become aware of that?
I was aware of this aspect quite early on, possibly in 2015 sometime. I knew that was sort of inherent in the design of measures. It was one of the perceived efficiencies of the program.
Okay. Now, could we please go to page 14, call out the section legal authority, in particular 10.1 in relation to Centrelink. Just read that to yourself. I'm going to ask some questions to you.
The complete thing.
Don't read it aloud. Just
but the whole thing that's on the screen.
Yeah, just if you could read that yourself. Would you agree with me that this part of the protocol is indicating that way in which data was to be obtained from the ATO by Centrelink was by way of notice under the Social Security Administration Act?
Yes, that's what it says.
Okay. I'm just going to ask you about paragraph 69 on page 16 of your statement, which is this. To my knowledge, for the data that I was familiar with, provided at paragraphs 13A to E of your statement, DHS did not issue a written notice to the ATO pursuant to section 196 of the Social Security Administration Act.
Yes, that's right.
Okay, so would you agree with me that the way in which data was being obtained for the purpose of the Robodebt scheme was contrary to this part of the protocol?
Yes, yes, I do. At some point, it has likely changed. What I mean by that is the drafting of this program protocol in 2004, that may have been accurate in the case, as in DHS or Centrelink probably at the time would issue a notice, but at some point prior to my joining the department and the team, the use of the Tax Administration Act or the sharing of data under the Tax Administration Act was become the mechanism to do so. That's incorrect.
Can you explain why notices were not being issued under that legislation in accordance with this protocol in terms of the program?
I can't be clear on the exact motivation. I mean, I know we had a very good working relationship with the ATO, and there was other data exchanges that used that same legal mechanism. I wasn't in the department, I suspect, when that transition must have happened, away from issuing notices under the Social Security Act and become reliant on the Tax Administration Act for that. Other than, I can't be sure why at some point that changed.
But if that transition were to occur, then surely this protocol would have to be amended to reflect that as per the guidelines.
Yes, it should have. When that happened at some point, it should have been amended.
Okay. That document can be taken down. The witness please be shown Exhibit 260, Doc ID ATO.001.635.2663_R. You agree with me, Mr. Lumley, that this is an email from someone called Michael Brown to yourself, CCing Tyson Fawcett, dated the 22nd of December 2016?
Yes.
Okay. You recall Mr. Brown and Mr. Fawcett, don't you?
I do.
Okay. Employees of the Taxation Office?
Yes.
And it says, good morning, Ben. Due to the media attention, the DHS compliance program is attracting our SCS, questioning whether the ATO has any exposure. Based on our discussions last week, we understand that additional processes are now in place from your end that should alleviate some of the programs moving forward. Are you able to provide a couple of sentences outlining these additional steps so that can provide assurance at our end? See that?
Yep, I do.
Do you recall receiving this email?
I don't recall receiving it. I mean, obviously I did, but I have no recollection of that.
Do you recall the media attention that the Robodebt program was attracting at this time? It's the time of this email.
So it's late, is in December, was it?
Yes, 22 December.
I do, yeah. There's a lot of attention on there, yes.
And do you recall, in a general sense, inquiries being made by the ATO of you about the program?
Yes.
And do you recall, in a general sense, the ATO expressing concerns about the program?
Yes. Yep.
And the ATO wanting some level of assurance about the program?
Yep.
All right. That document can be taken down. Can the witness please be shown Exhibit 2421, Doc ID ATO.001.924.1702_R. You happen to have that document in front of you, Mr.
Sorry, is there a reference, like a tab reference?
I'm sorry, I don't think I have one.
I mean, I'm happy to look at it on here unless there's a reason you want me to.
Beg your pardon?
I'm happy to view it on the screen unless there's a reason you want.
Okay, well,
I understand it's in the second folder.
Second folder.
That means something to Mr. Lumley.
Yeah. May take me some time to find, sorry. Sorry, I'm happy to look at it on these.
perhaps I press on. We go to the second last page. There's an email from Mr. Brown at the 3rd of January 2017, addressed to someone called Danny Scott. And can we take it from the words used in that email that Mr. Scott was acting in your role in early January 2017?
I don't think he would have been. What Michael's just made an assumption there. The reason why I say that is Danny was in a different area. Like it's unlikely he was acting. It may have been an assumption, or he may have taken on communicating with Mr. Brown on my behalf when I was absent, but I don't think he was actually officially acting.
Could the reference to Ben in this email be a reference to a different Ben, perhaps?
Not likely, just given my working relationship with Mr. Brown.
Perhaps if the witness could see the full document, it's the second last document in the bundle.
Okay.
Thank you.
Yep, okay, I have. Yeah. I'm just reading the content to
Thank you.
confirm whether. Yeah, it's unlikely it's referring to someone else other than me.
Okay. But the email refers or seeks a copy of the data matching program that was prepared for what's described as this program. See that?
Yes.
Mr. Scott, in the reply, says we are on to it and we'll get back to you shortly. You see that?
Yep.
And then there's a further email from Mr. Brown referring to a hope that we can also provide them with a copy of the data matching program protocol that the Gazette notice states is publicly available. Do you see that? It's the email of 4 January 2017, top half of the page with the digits ending 1703.
Yep, I can see where he says that.
Okay, and then the further email in the chain on the first page, at the bottom of the first page, from someone called Ian Stanley. And the statement is the program protocol related to the attachment is for the non-employment income data matching project. See that?
Yes.
And that's a different project, I understand, to the Robodebt scheme, is that right?
No, I believe it's the terms of reference. It's included.
Oh, sorry.
It is different to the pay as you go, if that's what you mean. Yes.
Yes.
Yeah, but it is considered to be part of the Robodebt.
Okay, be more precise. And it's different project to the online compliance intervention that was in force at the time.
Yes. I guess, but to be clear, that it was called the Needham project, based on the acronym. You'd have a future vision to use the online system at some point.
Okay.
I can't confirm if that ever happened, because my time in the department hadn't got there yet. But future vision was that we'd use the OCI.
Okay. And the words in the email continue that the NEIDM protocol is attached. And then the final words are, I have also attached the original program protocol for data matching pay-as-you-go, which would have been gazetted much earlier. See that?
Yes.
And that's the 2004 protocol we were discussing earlier, is that right?
I believe so, yes.
Okay. And then the final email in the chain forwards the previous emails you're CC'd to. Do you see that?
Yes.
Now, do you recall receiving this email?
No, I don't recall receiving it.
Okay. But do you recall, in a general sense, the ATO wanting to provide the media with a copy of the protocol that related to the OCI program?
Yes, from reviewing the documents, I saw that's, yes, they were after the protocol for that reason.
Yeah. And you recall media inquiries at this time seeking to access the 2004 protocol that related to PAYG data matching?
Request to DHS, media request.
Yes.
Yes, I was.
At about this
Around that time, I can't be exactly, but yes.
Okay. And that was in the context, as we've discussed, that the only place where the 2004 program protocol was publicly available was on the Government Gazette.
Yeah, it was gazetted at some point, yes.
It wasn't on the department's website at that time.
No, it was not.
That document can be taken down. Could the witness please be shown Exhibit 2761, doc ID CTH.3000.0023.8816_R. Go to the last page of this document. See, that is an email that purports to be from media. Do you see that?
That's like when you asked, was I aware? That's like what was coming to mind.
Yes.
Requests like that. Yes.
So media would be the media section of the department.
Of DHS, yes.
Yes, we're responsible for responding to media inquiries. Okay, and it's addressed to yourself.
Yes.
And you see that it says, can you please let us know if we're able to provide the data matching protocols to respond to the below? And the below is a series of media requests for access to the protocol. Yes. See that?
Yes.
And then the email from yourself at the bottom of 10 January, at the bottom of the first page on the 10th of January 2017, addressed to Kevin, who must have been in the media section of the department.
I recall he was, yes.
Okay. And you state, I've seen this request before and provide the response attached. Also attached, as you requested, are the NEIDM and the data matching protocols. The NEIDM technical standards report is an appendix to the protocol. And then in underlining in red, please be aware, none of these protocols actually relate to the current media issue. I do not recommend that are provided in response to this inquiry. All right. Now, the current media issues you're referring to are the heightened media interest in relation to the OCI program, correct?
I believe it would be this request, this media. There was some that was similar. They were asking for program protocols. But I believe in this instance, like I'm referring to this request. As in, I said I've seen it before. It's probably either a follow-up to one or of the same request.
Okay. And when you say the words, I do not recommend that are provided in response to this inquiry, what are you meaning to not recommend are provided in response to the inquiry?
No, so I do not recommend they are provided, meaning the protocols.
Which protocol?
The Needham one.
which one?
The NEIDM one.
Right, because they didn't relate to the relevant.
Yeah, there's a few instances, this being one, where questions have been asked of the department about the scheme that was rolling out, that it was getting media attention. At this point, we hadn't commenced the NEDM project. So to provide a program protocol, it would potentially be misleading or confusing because they were asking for the NEDM measure because it had been published recently. So they make the assumption it's that measure that's in the public arena. So essentially would have been providing the wrong protocol, which is why I recommended that.
I see.
What was the department doing about making it clear what protocol applied to the OCI program and making it available?
In response
Anything at all?
to requests like this, Commissioner?
Sorry?
In response to like a request like to this?
Well, yeah, and requests of that nature at the time.
I believe at some point I drafted some words to try to explain that, and back and forth with media and legals to explain exactly that. Probably some point beyond, after this. I mean, then some point in the future we went to things published on our website, but that was much further down the track.
Yes.
Just Commissioner, the witness might be assisted to know that the document Exhibit 2761 is tab 14 of Volume 1.
And what will that tell him, sorry?
Yes, it's like the proposed response that I was referring to that. I believe I drafted or had a role in drafting it, tried to provide some explanation as to the difference.
These are the words at the top of the email that's on the screen, correct?
No,
All that, sorry?
Can you give us a CTH reference, Ms Hogendoren?
It's the same, it should be the same document.
Earlier part of,
Oh, sorry, I see what
sorry,
you
it's just the earlier part of the
Yeah.
email. He's been taken to the end of the the earliest part of the email, but it's the back of the email and the hard copy, if that makes sense.
Yes, I see.
It is CTH.3.000023.8816 _R 2761 is the exhibit number.
Commissioner, that's, I guess, an example of a response where I was trying to clarify the difference.
Yes, thank you.
Thank you, Commissioner. So just coming to that email now, Mr Lumley. Just the opening words of the email, it says, "We are receiving several requests from media and the public to release the relevant program protocol for the department's new online compliance activity. The relevant program protocol is attached and I'm also seeking clearance on its release also, noting it is a requirement under the guidelines on data matching in Australian government administration." And in particular, when you say said here it is a requirement, what particular requirement were you referring to?
Well, I'm assuming the ones that we reviewed earlier.
About the protocol being publicly available?
Yes.
Yeah, okay. And then you've got your proposed response, which includes these words: "The information subjected to data matching to support the department's new online compliance activity is the ATO's PAYG information. The department has been working in partnership with the ATO for many years, and the data matching of this information has been undertaken for more than a decade." See that?
Yes.
Now, the email concludes with these words: "The program protocol supporting this data matching is the PAYG Data Matching Program Protocol attached. This protocol has been in use since 2004. See that?
Yes.
And may we take it that the attachment to this email was the 2004 protocol that we've been discussing?
Yes. I assume it is just based on the heading of the attachment. Yeah.
Can you assist us with whether you got the clearance that you urgently sought in this email? That is, clearance to provide the response with the attached program protocol to media inquiries.
I do recall it was a lot of back and forth following this request. I can't recall if I ended up receiving it, but if I did, it wasn't quickly. This way of describing it.
When you say it wasn't quickly, what do you mean?
Well, essentially that it was requests like this that essentially triggered the review, the update, the push to then publish it on the internet web page. And I believe sort of all that consideration started to take place as a result of this email, this request.
Right.
So it wasn't, I believe, I can't confirm if it was actually provided, but I just know it didn't happen straight away.
Right. So, at the time of these inquiries that were happening in early January 2017, there was a protocol in existence that had been applied by the department up to that point in time. That is the 2004 protocol, which would have responded to the media inquiries at that time. And you're not certain whether at that time that protocol was provided to the media in response to those inquiries.
That's right, I can't confirm. I do recall like it just taking time to go through the process of getting clearance, talking with the privacy team. Executives got involved with, the approval process. It just dragged on. That's the best way of describing it.
And as you've said, what also got triggered by these inquiries was a review of that protocol.
Yes.
And in particular, the realisation by you that the protocol had not been updated to reflect the OCI program, and was therefore not compliant with the Information Commission's guidelines. And if that protocol was disclosed to the media at the time of this heightened media interest, it would be quite embarrassing, wouldn't it, to the department?
Yes, I believe that was the concern.
Right. And is this right? Over the months that followed, the protocol was revised until to the point that there was a new protocol issued, which became the 2017 protocol. Can you tell us whether or not the 2004 program protocol was made publicly available before the 2017 protocol was made publicly available?
I can't recall when it was made publicly available. I can't confirm the timing of those two. I believe at some point it was published, or they are published on the department's website now, but I'm not sure when that took place.
The witness please be shown Exhibit 2806, Doc ID CTH.3000.0026.1169_R.
By way of assistance, that's in the second volume and it's the fourth document from the back.
You said fourth from the back. I'm not sure if that's correct.
Now,
Oh, yeah. Okay.
just for context, Mr. Lumley, this is an email chain that commences with an email from Mr. Ryman dated the 20th of February 2017. That begins at the bottom of the first page and goes over the second page. Do you see that? Yes. Okay. And Mr. Ryman, this is the 20th of February 2017, says to you, "Hi Ben, I need you urgent advice on a couple of things. I've reviewed the PAYG protocol and I've found a couple of points that will need to be we will need to be able to respond to if asked. Section 6.1 contains a paragraph that states before commencing the review, Centrelink staff will check the customer's record to determine if the discrepancy can be explained. And then Section 7 contains a reference, all remaining ATO data is destroyed within 12 months. See that?
Yes.
And he asks, in relation to the first point, we need to be able to explain how these have been replaced. It refers to another person who has reviewed the parts of the ERAF that details what steps were involved and has provided some commentary. Can you review as we need case selections input? In relation to the data retention, he has provided some, that is Alberto has provided some preliminary advice. And then if we go to your response, I'll just ask you to read it yourself without reading it aloud.
I've finished reading.
Thank you. So you respond to effectively 2 points that Mr. Ryman raised. Your response in relation to the destruction of ATO data is the main part of your response and comes before your response to his question about updating the program protocol. Do you agree with that in a general sense?
Yes, yep.
Okay. Now, the explanation, well, first of all, what you appear to be stating is that providing an explanation for is the process that was then being undertaken by the department was retaining data for more than 12 months. Agree with that?
Yes, I've come to the conclusion. I do remember seeing this in preparing my statement. I sought advice from a technical person in my team about the data retention, at what point that happened. As referenced in there, at some point in 2012, we had the ability to hold on to the data, and I mean by ability in a sense of technical capacity to do so. And the person that provided me that advice was saying that from that point in time, we did.
Okay.
Just so I understand the chronology, you'd have got the 2010-11 data in 2012, I take it?
That I had that same question when I look back through this. I believe that's right. The prior tax year, but was held on to.
Okay, so
was
you were
received.
sitting on 2010 to 2013, and that's how somebody came to come up with the good idea that you had this, these gold mines of unexplored data.
Yeah, there was. Yes, there was. I guess information there that showed the amount of potential cases and. Over those years, yes. Right. It was used as a source to inform the measures.
But if you'd complied with the protocol, you wouldn't have had them in the first place.
Correct.
Thank you.
Yes, if they were destroyed within 12 months, you would assume that you don't have the last tax year available.
And not only the protocol, I suggest Mr. Lumley, Section 7.5 of the OIC guidelines that required a decision as to further action in relation to each individual should be taken by an agency within 90 days of the data match cycle.
Yes.
You'd complied with that. Sorry, when I say you,
Yeah, I understand what you mean. Yep.
then you wouldn't have been holding on, the department wouldn't have been holding on to this data.
I mean, I must say, I know obviously some data was kept. I can't confirm what data was kept. What I mean by that is the way the matching process undertook, it would assign sort of risk ratings or keywords to customers based on the match. I don't know if it was just that information that was kept or if it was how much of the ATO data was kept. The reason why I say that, because for the measures to commence, the department went and re-requested those years again from the ATO.
When this proposal was being sold in the first place, it was on the basis there was something like 866,000 discrepancies for years from 2010 to 2013.
Yes, so there was information available to the department. I guess what I'm trying to say is I'm not sure whether, say, all the employment information or the pay-as-you-go information was held onto and used, or was it just, I guess, keywords? It is somewhere in my statement attached to that where keywords were attached and they gave a level of potential discrepancy. I do know I was requested to provide that to inform the measure, like as in just those keywords. I don't know if that was what was held onto or for more broader. I can't confirm what was
Okay,
held.
so it's a question of whether absolutely all the PAYG data was held onto or
A keyword that summarised the
some
risk.
proportion of the
Yep.
ATO data, but either way, if you
Well-
complied with guidelines, or the department had complied with guidelines and protocol, it shouldn't have been hung on to.
I guess the key, if it's just the keyword, that's, I mean, it's hard to say that's ATO data. What I mean by that, it's like a risk, like it might be PAYG VH1, like very high one, that was recorded against customer records. And the business rules that would determine that would then give an indication of the level of potential risk for that customer. It could have been as simple as that was held onto, and I know that's what I provided to inform the measures, that information. I can't confirm or deny what else or was or wasn't. The advice that I was provided to respond to this sort of implies that at some point data was held onto, but I did not find any evidence to say what data that was.
Who would know?
The department certainly would have a record of it. Potentially other people involved in the measures, although they would have had to possibly come to me to get that information, and all I have provided was those keywords. So potentially someone in IT in the department.
Just the last point you make in the email, that is in response to Mr. Ryman's first question about why or in relation to the updating the program protocol. You'll see the words at the end of the email. In regards to updating the program protocol, there was a body of work initiated by Graham Lyle while he was in the role to review and update the protocols, but this was not fully completed. See that?
Yes, right at the end, yep.
So was that review that you refer to there, a review that was conducted in the context of the development of the Robodebt scheme?
No, so Mr. Lyle was my predecessor. So the person I guess inquired to the status of that said that there was a review done, and that was before I joined the department, so way before Robodebt, essentially.
So
It's implying it wasn't completed. So.
What's the explanation for the program not having been updated by the time that Robodebt was initiated?
Look, I can't recall exactly why it was essentially not done or missed. I do know generally the department was kind of under the impression or assuming that very little was changing with the introduction of the Robodebt schemes, meaning very little change to the data matching process, and quite frankly that is true. The data matching process did not change, but as you saw sections of that program protocol which talk about the administrative actions, that result did change. So I conclude that it was probably a misunderstanding of what the program protocol covers, and therefore the assumption of it not requiring updating.
Can I just go back to what we were discussing before about the actual data being retained? You certainly seem to be saying in this email that it was, don't you?
Yeah, essentially I'm passing on information that someone technically advised me, and yes, it's implied in that the ability was there, therefore it was kept. I don't know, as I said, I never saw a record of what information was actually kept. I very much know that those keywords and things that inform the measure were there, and that's what was used.
But when you ask somebody about it for the purposes of responding to this, it seems that
It's
you
implied
got
that-
the information that the data was held.
That's exactly what's implied, yes.
Were you involved in the development of the Robodebt scheme, Mr Lumley?
Yes, I provided, as I mentioned, some information, data that was used to, I guess, identify the potential scope, numbers, things like that, yes.
Were you consulted as to the process that would be used for reviews under the scheme?
No, not so much that, not that business process. So I guess my scope or focus or expertise was the acquisition of data and the application of risk rules that would identify potential overpayments.
Were you consulted as to whether or not there was a need to review the program protocol as a result of the Robodebt scheme?
No, not until, as I mentioned, the media attention essentially had it landed with me.
Commissioner, that's the evidence of this witness.
Ms Hogan-Dory?
There's nothing arising. Thank you, Commissioner.
All right. Do you want Mr Lumley excused?
May be excused, Commissioner.
Thanks, Mr Lumley. You're excused. And I think we'll adjourn for the day spot on time. That's an unusual experience. Thank you.
All rise. The Commission stands adjourned until 9:30 tomorrow morning.
Oh, I had forgotten to mention, Ms Hogan-Dory, and I don't know if anybody had said anything to you, but because we have a lot of witnesses tomorrow, I was planning to start early, possibly take a shorter time for lunch, and perhaps end a little later.
Thank you, Commissioner. I understand Mr Barfoot and Ms Dalton will be coming by video link in the afternoon session, and I had been appraised of the 9:30 start, but thank you, Commissioner, and my team know that as well.
Right, thank you. You'd said we're adjourned, hadn't you? Adjourned we are.